Okay. This is only a small bench.
Acha, acha.
We'll
So we'll come back at 12 or
let us see. Let us see.
Okay, man.
My lord, I crave leave to mention on contempt application, my lord. Yes, this bench, my lord, before this bench. That
To mention on second appeal.
This bench, no. This is not a regular bench, sir. Just go on calling. Cannot to be mentioned. Why it is to be mentioned? Oh, who has filed? Yes, who is appearing?
I am appearing for the appellant opposite
What is
party.
this application?
This is a recalling application
Recalling of which order?
passed by your lord.
At what page?
Disposal of the
Yes.
appeal and the application.
Where is that?
Yes.
You are a respondent.
No, my lord, I am the appellant, my lord.
Then why don't you come in the appellant side?
In this opposite party, my lord, in this application, opposite party.
Oh, you are opposite party. Then remain. Who has filed?
The Lipika Chatterjee, the respondent in the appeal itself.
No, there is the Vakalatnama which is filed is by Arindam Chattopadhyay. Care of Lipika Chatterjee.
Yes. They are intended.
Tarkeshwar Majumdar, Falguni Kanjilal, Kanak Das.
Yes. They filed this application for recalling of the order dated 6th September 2023.
6th September.
Yes, ma'am.
What we did?
The dispose of the appeal by setting aside the order based on the fact that at that point of time, NL Global, considering the NL Global, injunction cannot be granted.
What they have said that the service has not been affected.
Service not been properly affected. I have earlier occasion I have satisfied your lordship that the evidence service was filed indicating that door locked and door locked. Considering that, my lord, your lordship was pleased to admit the appeal and dispose of the same.
Which?
Beg your pardon, my lord.
No. What do you say?
According to them, my lord, they did not been served with the copy of this application before the date of hearing. According to I filed the evidence service of the date of booking of this appeal, from where it appears that it was mentioned that door locked, it was served. Considering that, your lordship was pleased to admit the appeal and allowed the decide the matter expert. And on the earlier occasion, I have also. Yes. Your lordship was pleased to ask me whether the door lock can be found to be a good service or not. On the earlier occasion, my lord.
So nobody is coming. Then what to do? This matter has come up by way of an assignment. Let this application be listed after fortnight. Let's call the next.
There is a section 5, my lord.
Have you served?
No, my lord, this is for the first time it has come before your lordship.
Lordship, item number. Who continue?
Where?
The matter which was taken up by your lordship day before yesterday.
Have you not seen what is the bench?
Is different.
You are a seasoned lawyer, don't you know? Service 2 weeks after. What is the defect?
No, I have filed for review of the order
Out of
judgment
time,
dated.
sir.
My,
Section
oh,
5 is
defect.
there.
My lord, I have filed section 5
Have
application.
you served?
Copy served.
Where is the affidavit of service?
My lord.
Without any order, copy served. The review judge.
In my section 5 application, my lord, I have explained through a chart at page 6. Top, my lord.
Where is the service?
Handed over, my lord.
First thing is that it is out of time, sir. You have to cross the hurdle of condonation first.
My lord. Page 6, my lord, I have explained.
Yes?
There is a delay of 1 day,
1 day.
my lord.
Our reporter, stamp reporter says 33 days.
That's I have got, my lord, that information. But
So,
subject to, my lord, kind consideration, subject to correction, I have
when
stated at
the order judgment was delivered on 28/4.
28/4.
When you applied,
Thereafter, my lord, vacation commenced on 20th/5.
no, that will not do, sir. You will not get an advantage of that. Because 28/4 was the date for
My lord, kindly consider my calculation, my lord. Thereafter, my lord, kindly.
correct. Let us understand that what you understand about the calculation.
Page
So
6, my lord.
date of the order is 28/4.
28/4, my lord.
Yes. Then
Page 6, my lord.
no, just
My lord,
tell me. Then
vacation
you applied for certified copy on
vacation
15/6.
15/6.
Yes. Now tell me.
My lord, vacation commenced on 20th May,
20th May.
May
Yes.
2023.
Yes.
Here, my delay was 21 days
Yes.
from the date to vacation.
Correct, sir.
Vacation ended on 5th June 2023.
Correct.
I applied for certified copy on 15th June 2023.
Correct. Sir.
Here is my delay is 10 days.
This is the way you understand calculation. That's why I kept mum, just to understand that what the juniors will learn from the senior about the understanding. This is a way. Do you have the copy of the Limitation Act with you?
No, my lord. That's not.
So for your junior, I think it is necessary to, because she will learn a very wrong law. So it is better to have what is the period of limitation is 30 days.
30
I
days.
believe so.
30 days.
30 days. What section 12 says of the limitation? In computing the period of limitation for any suit, appeal, or application, this is an application review. The day from which such period is to be reckoned shall be excluded. Means if it is 28/4/2023, then that day shall be excluded for the purpose of computation. It will start from 29th of April. Right? In computing the period of limitation for an appeal or an application for leave to appeal or a revision or a review of the judgment, the day on which the judgment complained of was pronounced and the time requisite for obtaining a certified copy of the decree, sentence, or order appealed from or sought to be reviewed shall be excluded. So this is on 28/4, it is to be excluded. And if you apply, then the period for which it is to be made ready shall be excluded. Where a decree or order is appealed from or sought to be revised or reviewed, or where an application is made for leave to appeal from decree or order, the time requisite for obtaining a certified copy of the judgment shall also be excluded that time. In computing the period of limitation, to set aside, this is not explanation. In computing this section, the time requisite for obtaining a copy of a decree or order, any time taken by the court to prepare the decree or order before an application for a copy thereof shall not be excluded. So the computation would done. When you say the holidays, then holidays is it is when the court reopens, then you can apply that period has to be reckoned. Nothing more than that. Section 4. Where the prescribed period of any suit, appeal, or application expires on a day when the court is closed, the suit, appeal, or application may be instituted, preferred, or made on the date when the court reopens. So it is for the purpose of filing, not for the purpose of computation. Admittedly, within 30 days, you did not apply.
Right.
You applied
Right.
beyond 30 days on 15/6.
15th June.
And the court reopens on 5th.
On 20th May.
That closes.
Closes. Yes, madam. 5th June. 5th June.
So 5th June, thereafter 10 days you applied, then the entire period of the
That will be under
which is
computation.
spent has to be
Counted. I shall correct, madam.
Mm. Because the juniors who have just joined the bar, they will learn the wrong law,
Certainly,
which
madam.
I
That
do
is
not want.
absolutely, madam.
And you junior never learn from mouth to mouth. Somebody has said this is the law, you understand this is no. Read the section. Whenever anybody says, read the section. Find out what is there. From where you got this impression, sir? You are a veteran in the profession, having a long
It is
standing. Why have you never calculated that this is section 12 is a primary section for the purpose of computation? And you never care to read that particular provision for the purpose of computation.
Kindly forward.
How it's to be computed. Very meticulously, this section says that how it has to be calculated. Computation. So I think my stamp reporter is correct.
Fine.
So what you have done? 1 day delay, you have explained. And the wrong proposition. Then what can be done, sir?
Kindly give me liberty to correct, madam.
Wrong calculation. Because you have said in paragraph 4, which is
Yes.
absolutely contrary to section 4 and 12. What can be done, sir?
Liberty may be granted, madam, to correct
Hmm?
that. Liberty granted, my lord.
What liberty? This is the part of an affidavit, and very interestingly, this particular paragraph is affirmed as true to the knowledge of the applicant. Applicant knows how to compute the limitation.
A simple liberty.
This is the way, or it should come as by way of submission, or it should come by way of information or anything. The advice received from the client, which from the advocate, which I verily believe to be true. Will you not affirm this paragraph like this? This judgment delivered on such and such, vacation commenced on such and such. Here is the delay of 21 days. Vacation ended, applied for certified copy on 15/6. He thought that 10 days from there it will run. Exclusion. No, there is no exclusion. It's not an exclusion. It is really an extension of time. That if the limitation falls within the vacation of the court, then it is not an exclusion. It is really an extension, that the time is extended till the court reopens. And on the reopening, if you file, it will
Then
be
it will-
deemed that you have filed within the period of exclusion. That period is to be excluded from the limitation. No. Section
Kindly-
4 does not say so.
My lord, kindly give me liberty to file a supplementary affidavit, my lord.
Leave is granted to the applicant to file the supplementary affidavit within 2 weeks from date. So the copy of the supplementary affidavit shall also be served on you are here. Okay. The copy thereof shall be. You have received the copy of application for condonation? Yes. So copy is to be served. Give your name. हाँ, एकेबारे। Yes. This
Well,
review application, sir.
Yes, my lord.
Which order?
I'm sorry, my lord.
Which order?
My lord, this is, my lord, a judgment, my lord, and decree, my lord, dated 24th April 2023.
Sir, out of time again. Any application for condonation?
No, my lord.
Why? 190 days.
My lord, I'm given to understand that, my lord, we applied for a certified copy of the decree, my lord.
Within the time.
After, yes, my lord, within, my lord,
Within
my-
30 days.
my advocate on record, my lord, is not sure about it, my lord. I
He's
believe
not
that,
sure. He has applied and he is not sure.
my lord, he's not sure.
Who applies? The advocate or the clerk?
The advocate, my lord.
Advocate. So the judgment was of 24/4.
Yes, my lord.
Application was made on 23/8. Apparently.
My lord, kindly allow us to, my lord, prefer an application for condonation in that.
Date of application, certified copy. Judgment is of 24. So obviously it is more than 4 months. Apparently.
My lord, kindly allow us to then prefer an application, my lord. We'll come back, my lord.
Second hurdle. How can you file a review with 100 rupees? $49,900. What to do? You nowadays you do not care when there is a defect. You should go through the file before the matter is called on.
My lord, kindly allow us to, my lord.
The staff reporter indicated that the instant review application is filed with a deficit court fee of rupees 49,900. So furthermore, it is also reported that the instant review application has been filed 190 days. from is filed belatedly, and there is a delay of 119 days. There is no application for condonation of delay accompanying the application for review. In such view of the matter, let this matter go out of place to enable the applicant applicant of the review application to take appropriate steps.
My Lord, Lordship may grant us liberty to mention, my Lord, upon my Lord, defects being complied.
Suppose if we do not grant, will you stop from mentioning? It's a farcical approach, liberty to mention.
As my Lord deems fit. my Lord.
Call the next. Right. Again defective. What is the defect?
Plus, we have filed affidavit of service. Plus, we have served the other side also.
Defective.
Yes. Plus
What's the
8
defect.
81 days delay, Malas. We have filed the applications for condonation of delay also, Malas.
81 days.
81 days.
Have you served the copy?
Yes, we have served the other side
What
also.
is the service?
Malas, I'm told by learned friend that the commissioner has not yet come, so therefore, Malas, we can do it. Well, I will be filing in course of days, Malas. It's the done.
এটা আমার মনে আছে, it was practically on a consent of parties this judgment was delivered. Mr. Roy, if I correctly remember, my memory do not betray me.
Yes, Malas. No,
Was
I'm sorry.
virtually filed on the
I'm
consent of
sorry.
the
I'm
parties.
sorry. So what that part is concerned, I've taken specific grounds for that also. When the matter went to the Supreme Court, Malas, I appeared, and this was the mistake which has been pointed by the court. Mistake on the part of the council, Malas.
No.
And it's settled that law, Malas, law is very settled. The wrong concession made by the council without instruction.
No, there are two aspects.
Yes.
One is the wrong concession on the proposition of law is no concession in
Yes,
your law.
Malas. On fact.
But wrong concession on
On
the
fact.
fact,
Yes.
then there must be a strong case that has to be made out.
Yes,
If we
Malas.
remember
I'll
this
show
case,
your lordship. Sorry.
the gentleman who is now assisting you was there.
Yes. No, he is not. It's a different set of lawyer over there. Therefore, I said not to
Now,
take. Malas.
now,
Yes.
can you maintain a review application after AIR 1997 Supreme Court page 1005?
Malas, I'll see to it, Malas. I
Bring that
that's
judgment
well.
of AIR 1997. Supreme
Malas, I
Court.
have cited, taken in the ground that, Malas, the mistake.
Take that.
Okay, Malas,
Supreme
let
Court-
me repeat
The
one thing.
Supreme
Malas.
Court has deprecated
Yes, Malas, let me
the
repeat once
review
again.
application to be taken out by a new set of lawyers.
Yes, Malas.
And to say something, the Supreme Court imposed a hefty cost on that. AIR 1997 Supreme Court, page 1005, if my memory goes right.
I'll see to it. I'll see the judgment, Malas.
Hey,
Malas, here the case, Malas. Malas,
sorry,
Malas.
we can't. First thing is you cross that hurdle of the Supreme Court.
Malas, this
Judgment.
matter went to the Supreme Court also for your lordship.
Whatever, that
Supreme
does not
Court granted
hey,
liberty when I show the report of the commissioner, which has been wrongly
এখানে আছে,
relied upon.
97. এই, পড়ে আছে। It's
Which-
nine.
I'll see to it, Malas. I promise that I'll see to it, Malas.
Yes, the page number is also correct.
I know your lordship's memory.
I'm reading paragraph 1. It is a sad spectacle that a new practice unbecoming of worthy and conducive to the profession is cropping up. Mr. Such and such, advocate and record, I am not saying name, has filed Vakalatnama for the petitioner respondent when the special leave petition was filed. After the matter was disposed of, Mr. Such and such, I am not naming, has filed a petition for review. That was also dismissed by this court on to April 24, 1990. Yet another advocate, Mr. Such and such, who has now been engaged to file the present application is styled as an application for clarification on the specious plea that the order is not clear and unambiguous. When an appeal or special petition is dismissed, except in rare case where the error of law or the fact is apparent on the record, no review can be filed. That too by the advocate on record who neither appeared nor was a party in the main case. It is salutary to note that the court spends valuable time in deciding a case. Review petition is not and should not be an attempt for hearing the matter again on merits. Unfortunately, it has become in recent time a practice to file such review application as a routine, that too with a change of counsel without obtaining the consent of the advocate and record at the earlier stage. This is not conducive to healthy practice of the bar, which has the responsibility to maintain the salutary practice of profession. Such and such, and then I believe after this review application dismissed with hefty costs. After this, what you have to say?
Yeah, the case,
Yes.
Supreme Court,
Take
with respect, I say,
Read.
with
First
respect,
paragraph I read.
yes, I've
Right hand side.
yes, I've got it.
জানেন তো এটা ওরা কিছু করে enough করে দাও আমরা রাজি আছি on that basis আমি দেখে নিয়েছি ওটা বাকি তো সব হয়ে গেছে আপনার গ্যারেজ আলাদা করে
I've seen Manus. Did not have seen, and this is what
So
Rashi was-
strong word, strongly
Yes,
worded.
it was,
Right?
Manus. But here the case may,
No,
with respect, Manus,
no.
can I,
Have you taken a change from the earlier advocate?
Manus, because the client has no faith on him.
I do not know, but you'll have to. Supreme Court has said
Then Lashmi,
that you can't.
Lashmi, give me,
you
allow
can't.
me to client to give give an affidavit
No,
by
that's
saying,
not necessary, sir. It's
because
not necessary.
impression of the client was he betrayed. Because there is no partition.
If I correctly remember,
Yes, Manus.
the argument was advanced
Yes.
from both the corners. They said that so far as the other part is concerned, they have no grievance. They have
Only
a
garage.
grievance with regard to a garage.
Garage.
And then they agreed before us that the garage is divided half and half, given
Manus.
to both.
Manus.
Then there will not be any problem in this regard.
Yes.
This was the understanding. On that score, we proceeded and then said that when the parties, because we wanted the litigation to end, we have a sad experience about the partition suit, which
Yes.
lingered on for a pretty long time
Yes, so interesting.
on a fringe issues. So that's we said that the good sense has prevailed. So literally we said that it can be done in this way. There is no
Let's-
difficulty.
May I submit something?
Now
When
once
I-
it has come,
Malas,
no.
when I shown the report of the commissioner, Malas, Supreme Court found that there's a commissioner report, the garage has been already been done. Division of the garage has already been done. Malas.
that division was not there. Half and half was not
Yes,
there.
first floor and ground floor.
That is a different. Garage was remained there,
Yes.
and they were having a problem with the garage, and they come up with the solution that if garage is divided into two halves.
Malas,
So that is what we really did, and it is really a consensus order.
Malas, therefore,
It's
Malas, I am
really a
for your
consensus,
lordship. And have taken
order.
a specific grounds to that also, Malas. It was not the, Malas,
We
we,
will have to bring. We will give a notice to the advocate and record.
yes, Malas, he will,
Instruction, no
he will,
instruction.
he will,
But,
Malas. Here,
but we will dismiss with hefty cost on that.
Malas, lordship may, because Malas, lordship will, and I'll,
Dismiss with hefty
yes,
cost.
I'll call the earlier advocate and record. Malas.
97, that money just
Malas.
turn the page.
Yes, my
On that page?
20,000 was the
Yes.
cost. I've seen
So
it.
it was too
I've
small
seen-
an amount.
No,
One more zero would be added to it.
no, it's not that.
Not before two, but after two.
Let that advocate early advocate come.
Definitely. Why?
Malas,
You have to bring it. No.
Malas,
After this judgment, how you can
Malas,
overcome?
Malas, may I, since Malas, I have the idea of the practice in Supreme Court, Malas,
That is what I say.
Malas here, that without obtaining no objections to the earlier council, review was filed. What I guess found from this, but at the
No,
Supreme
that was an observation that
Yes.
you ought to have taken a no objection because the review sometimes sprung from the main proceedings.
Yeah, that's
And therefore, if you want to, there is an error, then the advocate who represented the party has to come and apply that what is an error because he knows that what he has argued.
Malas,
And now Supreme Court has said the different approach, something else. Now, what you are saying is you are really putting an aspersion against the advocate and record or the advocate representing your client when the main appeal was disposed of.
yes, Malas.
It's an aspersion. If we accept that this is the reality, then there is a chance that matter may be referred to a bar council.
Very
But the lawyer is not supposed to concede on facts without a specific
Yes,
instruction in
Malas.
this regard. But again, I'm saying, so that's the way I have a principles that advocate has to be here. Here, if he says that I have received the oral instruction, it's because if we remember,
Yes,
we adjourned the matter on 2 occasions. Because on the first day when this happens, then he says, I can't because I have to take an instruction. He was fair enough. I think who was there? Mr.
Anjan Dattu.
Anjan Dattu. He
Yes.
was fair enough and says that I can't say.
Yes.
Next day says that I could not contact the advocate, my client. Please grant me some more time. Then on a third day says there is no difficulty. I had a talk. And if it is divided, we have no problems.
Prime Minister, I can show to your lordship, Malas.
Sorry,
Malas,
if he says, then it's difficult.
lordship trying to save the interest of the parties. Malas,
No.
only house,
No.
both the brothers, one is in the upper floor. They are getting 1,018 square feet, and who is there in my client?
There was nothing. They says there's nothing so
Plus,
far as that.
I can
party-
show from the
No.
report itself, garage has already.
And
been
where is
taken
the
to consent.
observation of the Supreme Court?
Yes, Supreme Court has granted liberty, Malas, to approach this court, Malas.
That you know in what circumstances the liberty is granted.
Malas,
You
when
had you
when
had an
pointed out.
experience. I
Malas,
had.
I argued the
You
case.
have an experience. I had an experience.
Yes, I know, Malas. I did not say no to it, Malas.
What
Lordship
what
had the
happens
experience.
when SLP is taken
Yes,
and this observation is made?
yes. Malas,
You know
Lordship,
what happens actually.
specifically, I showed to the court.
He knows. He's a regular.
It's 26, the order of the Supreme Court, Malas.
Seen.
And this,
And you know,
I know, Lordship has seen it, Malas. Yes,
and you
Malas.
know how
Malas,
and
I,
under what circumstances it is passed.
yes, I was the counsel, Malas, when I pointed out from the report of the commissioner and the case map, who said, have you argued this point? I'm like, yes, Malas, it was there. But because of the counsel appearing for the petitioner, because of the, Malas,
We are live. I am not going to say many things
Lordship should not, because I know, Lordship,
live.
I mean,
I do
so
not
much
want
of
to-
experience
I
about
do
Supreme Court.
not
I'm
want to
the witness to it. I'm witness to it. Malas. Lordship has been in many a time. They are in Supreme Court, Malas. Many a times, Lordship have been in Supreme Court.
No.
Lordship, kindly save the interest of the parties. Let them
No.
No. Stay safe, Malas.
No.
Because there's two brothers in the same house.
I know. That is what is
And
there.
I
But,
can show from the
where is you just bring him the other
Yes.
side. I mean, the advocate on record,
Yes,
Mr. Anjan Datta.
yes,
Bring
I'll
him.
bring him. And my client also present in the court.
adjourn.
They have instructed, said, no, this was not the submission, the conference we made with this council has made his.
Difficulty sometimes happens is that the advocate sometimes they rely. If he has come, there is no mechanism that they will just record whatever has been done.
Yes.
This is done in European countries where everything is recorded and then transcriptions are done.
Yes, ma'am. Now in Supreme Court also
And then,
started.
and then it is sent to the
Supreme
client
Court
that this is what
transcription,
it
Chief Court, two
happens
courts have
for
started.
ratification.
Yes.
This is, but we are not.
Now
we
it
have
is by the
not
Supreme
started.
Court. We have the transcription system. You can see whatever they argued and who has
No,
argued.
this is what a live streaming. I am
Yes.
saying we have inculcated a system that the communication between a client and a lawyer is a privileged
Yes.
communication. Is not
Loco
supposed.
parentis malus is
But
called
in
loco parentis.
other countries, I know that the entire communication or conversation is
Under this-
recorded
Under
and it is
surveillance,
there
yes.
and then transcribed, sent to the client that this is what has happened.
Yes.
And thereafter, after waiting it, then the council comes and moves.
Yes, malus, yes. It happens.
But here it is a privileged communication. That is why everybody is so open. The client may defy and say, I did not. I did not. Is it?
Malus, I call the lawyer malus. But you can
Sorry,
pass it
he
over
can't.
forward.
Anyhow, bring him.
Yes, I'll bring him malus.
It's
I mean, ask
simply-
specific questions to
Simply
the client
adjourn.
also.
No.
Yes. Let him come malus. I'm grateful to Lucius.
And look at this judgment and then come. Yes.
What malus should I come at 2?
This is the judgment you come.
Yes, malus, I've seen the judgment. Malus.
Please.
I have seen the judgment, malus.
The Boitani
This is the book.
is called the next matter.
Malus, should I come at 2 p.m.?
God, we are sitting for a day only. Let it appear on another day.
Malus.
No, we can't because there is a regular bench. And these are
Within
the
10
review
minutes,
and
malus, my instructor always by within 10 minutes, I can call him.
so we are taking up other matters. In the meantime,
Okay,
you
meantime,
call.
I can interpret.
Call it.
Okay, malus. Okay.
May it please your lordships. Contempt petition, land losers, they have not processed the case on the ground of non-matric and overage, which was deprecated by your lordship by the last judgment which was passed.
Yes, file your affidavit.
But
File your affidavit.
I shall file my affidavit
Correct.
disclosing that everybody have got appointed, excepting very few. I shall file.
Affidavit.
I have come with the list of appointments.
Yes. 2 weeks, 2 weeks, 1 week, 3 weeks hence. Yes.
Therefore, shut up. Again, the same thing.
6, 7, 8, 700, I shall file.
Yes.
Apply them.
File.
7 and 8.
Affidavits.
Lordship will give a date.
I am not
I
there,
know,
but
I know,
you-
my lord.
that's why we say in the meantime you do it, we'll sit one day because we didn't know that how so much of matters are pending. So we'll take up all this.
That's why I mentioned, I'm grateful to my lord.
First thing is they might get an opportunity to explain, thereafter the rule, then thereafter.
Yes, sir. You're ready.
Lordship, I'm grateful.
The direction was given, Millet.
Lordships, on the last occasion, direction was given for
For
filing.
affidavits, you have not filed it.
No, today is the date, and after that, I'm filing it here.
Sir, on 23rd of December, the office note says that 2022, it says no affidavit in opposition.
My respectful submission, Millard, I am at, Millard, this matter is appearing after 2022 when the direction was given for filing affidavits. We have prepared it, affirmed it,
Within time?
served it, my lord.
Within time, 3 weeks.
My lord,
It was
just
passed
allow
on
me.
11th November.
My lord, will
Within 3
kindly
weeks.
allow me a second, my lord. I'll just see on which day the matter has been affirmed, my lord, and reply has
Where is
not yet
Mr.
come.
Sauri Ghoshal and Prabhat Kumar Singh?
Yes, my lord. On 2nd of December 2022, my lord, we had affirmed it, and my lord, we had served a copy.
Anyhow, thus we got it. Where is
5th of December.
where is he?
I don't know.
Mr. Shauri Ghoshal.
I don't know. I have no clue.
What is your stand?
My stand is that
Has he filed a reply?
yes, he has not given a reply.
Not given.
After seeing my opposition, I suppose he has no reply. Because this
Obviously.
is a ground of compassionate appointment, my lord. What has happened is he's wanting appointment as a matter of right. And he has filed a contempt application in order to exert his right for being given compassionate appointment, which is not the proposition of law. Now, my lord, in my respectful submission, the order which was passed by your lordship,
It was a earlier division bench. That order
lord
is of
said-
7/4/2015.
my lord said
It was
that-
only a consideration.
yes, my lord, we considered him, her rather, and on the point schedule, with as per the rules and as per the DOPT notification, she came 6th. That was communicated to her. Subsequently, this contempt application was filed. We have categorically stated that on oath by way of affidavit in opposition. I am humbly submitting it, my lord, because the contemptor is not represented. My lord may adjourn it for a day as a matter of for the ends of justice. Because I don't want to, my lord.
Oh, this is. Have they indicated that any vacancy arises?
My lord, yes, we have indicated. She participated.
No. You said that respondent number 4 therein was the last appointment was on 5th December 2014.
My lord,
And then
my lord will kindly see. We have affirmed affidavit with all the documents. What I am on, lordship, very humbly. I apologize, my lord.
There was a direction to consider because it
My lord.
appears from the order dated 7/4/2015.
Yes, my lord.
I think
My
this
lord,
is
will
the
kindly-
order where they wanted to say something on that.
Yes, my lord. The order date is
This
7th
order,
of April
he says,
2015.
it
my lord.
says that the petitioner was already included in the panel
Yes, my lord.
and of compassionate appointment, and
Yes,
he or she, I do not know, she will be considered as and when her turn will come. Then the court says that all the posts reserved for compassionate appointment has been exhausted, and the last appointment was made on 5th December 2014. So far as the respondent number 4 is concerned,
my lord.
she must be after that
Right.
in panel.
Right.
Then the court says that yes, I am satisfied that she cannot be appointed on a compassionate ground at this stage. However, the court says that the claim will be considered if there is any availability in future. That is the only order.
Right.
Have they said in the petition that there was an availability, further vacancy, and she has not been accommodated?
My lord, may I put it this way? After this order was passed by this honorable court in 2015,
Yeah.
17, 18, and 19,
Yes.
thrice we gave letters that vacancy has arisen, you please apply. 19th, she applied. 2019, she applied with all the documents.
Yeah.
Her appointment was considered.
Yes.
According to our numbering basis, because compassionate appointment is how much you are earning, what is the financial position, so on and so forth. That was considered, a tabular form was prepared, and she was informed that on consideration, she had ranked 6th. 3 were non-technical, and 2 were technical. But again, in spite of that, out of 5 posts, she was ranking 6th. So she came up now, when all these things have been done, the order of this honorable court has been complied, because it cannot be a matter of right that getting a job. There's a process, and the process has been followed. Now, if she is aggrieved by the process, a writ application lies. I cannot sit in the advisory jurisdiction. Now, my lord, in my respectful submission, my lord,
None appears in support of the petition. Dismiss.
my lord will kindly keep this on record. my lord.
Let the affidavit in opposition filed today be kept on record. It is submitted by the respondent that he has not received the copy of the reply from the petitioner.
And my lord, affidavit.
There is
and
no
opposition
appearance.
was
There is
served
no
on them.
there is no appearance on behalf of the petitioner. The contempt application is dismissed.
Indebted, my lord. My lord.
Yes, my lord. My lord, last occasion on my lord 23rd June 2023, your lordship's passed order directing the contemner to file opposition.
Yes. What is the special lay petition? What is the fate?
Just
Admitted?
my lord, till now I have not affidavit of opposition received any served any copy of the opposition.
Sir, what has happened in the special lay petition? I just want
My
to
lord,
know.
today
That they have been served with a copy of the SLP and they have prayed for time to file an affidavit countered before the Supreme Court.
No, whether the SLP has been admitted.
Yes, page 57 of the affidavit.
Issue notice. Yes.
my lord, counter affidavit file. My lord, we have already filed one counter affidavit. So,
Yes. It appears that the special petition filed by the LS by the state respondent is pending before the Supreme Court, and therefore let this contempt application be adjourned sine die. Liberty to mention after the disposal of the special petition.
The affidavit filed today be kept with the records. Affidavit filed today be kept with the records.
Let the affidavit filed by the contemner be kept on record.
Yes.
My lord, I don't really think I am for the petitioner. I am for the petitioner, my lord.
First time?
No, my lord. Contempt application have served. Thereafter, my lord, the authority concerned communicate the order and by way of supplementary evidence, I have annexed.
So affidavit opposition was
Yes, my
extended.
lord.
Has they filed?
Yes, my lord. I have filed also reply, my lord.
Yes. Mr. Tapan Kumar Mukherjee,
Yes.
you appeared with Miss Tuli Sinha. Where is the opposition? Where is the affidavit opposition, sir? Which window could I?
Copy of the opposition has been served to me, my lord.
Has been served.
Yes, my lord.
Where is your opposition, sir?
Lekin not today, most probably.
এই অর্ডারটা দেখাও অর্ডারটা দেখাও নাকি your name is appearing. No, that's the last order. You asked for extension. Extension was granted.
Yeah.
Now where is the opposition? File it.
But my left hand has been served with a copy of the
Yes.
opposition.
He has also served the reply. You have to file your opposition. Where is your opposition?
That Julian is not here, but can you make it not today?
No, this bench is sitting. What is this going on? This is not expected.
Sorry, my lord.
You don't have a file.
My brief has been given to prepare the file, return it, but nothing has been done for me.
But have you not they corrected the opposition? Because you are the arguing counsel.
Yes.
So
I have settled it, then I returned briefs and the reply. Final copy, but nothing has been returned. That's the difficulty. Can you make it not today?
not today then. Let's call the next.
Next date, my lord.
After 2 weeks it will.
Yes.
But I'm for the writ petitioner applicant, your lordship.
First timer or the
No, lordship. My lord has heard this application on 3 occasions.
yes.
My lord, before coming to the order which has not been complied with or has been complied with just to facilitate some blue-eyed men, your lordship, may I summarize the fact? I'm led by Mr. Shomo Mojo.
Yes. What?
Your lordship, may I summarize the fact, your lordship? My lord, the entire dispute arose in the
Any opposition was directed to be filed.
no lordship. A compliance report was directed to be filed. The state has filed that.
What? Oh, so he has, according to them, they have complied.
According to compliance, because PSC has recommended. So the recommendation of the PSC are not.
So has been it has recommended.
But can the state take advantage of a fruit of contempt? Apparent contempt.
What?
Not persons who are senior in rank in the gradation list, they are to be automatically promoted to the rank of DIG, correctional services. Now, not admittedly, the two persons who were senior to me, they were facing disciplinary proceedings. And therefore, the state could not have promoted them to the higher rank. Now, not charges were serious, not providing narcotics in the cells, not theft of fish and the timber from the jail compounds. Now, these are the allegations against the persons concerned. And I was the sole untainted person, so to say, in the list. Now, not be that as it may, your lordships directed that PSC has to do in a particular manner, act in a particular manner.
Say that proceed with the filling up of the post of the said promotional post in accordance with the procedures applicable in this regard and shall permit all the eligible candidates, including the applicants, if otherwise not entitled to by any reasons, prior or subsequent to the order of the tribunal, and shall complete the exercise within 6 months. So they only direction was to proceed for filling up the promotional.
Yes, but please see
how they filled up is not a concern here. Have they filled up the promotional?
They have filled up long after the 6 months time period, allowing the persons to serve their penalty period so that they can be accommodated.
That is a different.
So please see paragraph.
Then go there.
Please see paragraph 5 of the report. Apparent contradiction in the report of the state. That as per the gradation list of eligible candidates for promotion to the post of Deputy Inspector General Correctional Services, the following mentioned Superintendent of Correctional Home, namely Debashish Chakraborty Satya Prakash, page 2, paragraph 5 of the report filed by the state.
No, page 2, paragraph 5 is not there. Paragraph 5 is at page 4.
But there is a compliance report by state in respect of CPAN 360 of 20.
What is the compliance report?
Compliance report filed, already been filed. And by the Secretary on 17th of May 2023. Jagadish Prasad Meena.
Oh, you are talking about Jagdish. See, it is for container number 2.
এটা দিয়েছেন তো এটাই তো মনে হচ্ছে Are in the your lordships have got that names of persons in the zone of consideration for promotion and the said gradation list along with the
name. Yes, you have been promoted. Oh, it has come It has come in the paragraph 8 of the today's compliance report. He says that the board meeting was held on 2nd of March 2021.
That compliance report on behalf of public service.
Correct. That is what I'm reading. The commission recommended Subhendu, that is you,
My client.
who was at serial number 2. The commission did not find another person, serial number 1, suitable for his promotion as departmental proceeding was in progress against him. And say it may also be noted that the Joint Secretary, Department of Correctional Administration, was present in the meeting. The recommendation was communicated to the department on 5th March itself. The photostat copy has been annexed here too. Then it is further submitted that after the recommendation of the name, the petitioner, the petitioner being aggrieved with the recommendation of that serial number 1, filed one application OA in such and such. And then
That's not the
prior fact.
that's the prior fact.
Prior to that.
Sorry. Now, where is the report of the, according to you, it is pending with you. You have not done anything.
Exact situation that after.
No. This you say that this is submitted. The proposal sent by the Department of Correctional Administration is under process at the commissioner's end.
It is of 2023. I am submitting after the instruction is given by the authority. I am submitting the latest position.
But in my application, I have given the latest position vis-a-vis the contradictory stand taken in the report filed by the state.
It was informed that 22nd December 2023 Commission has sent its proposal to the state court.
Whom? The petitioner has been.
Not the person who was found to be guilty of contempt for having benefited a prisoner as held by this honorable court sitting in criminal jurisdiction has now been promoted but taking the lapse of time and in violation of your court's lordship's order. I have annexed that order of the honorable court. Why the state allowed this time to lapse, then not mitigate the penalty, did not take cognizance of the order passed by the court passed in this criminal jurisdiction, holding the promoted to be in contempt, guilty of contempt. This is a clear subterfuge.
Yes, Mr. Mukherjee, how can you do it?
Your lordship can see.
What's he?
On the basis of the order passed by your lordship, we have sent it to the PSC. PSC after recommendation also.
How can he be taken into consideration? The other person who has been found guilty, there has been a lot of serious allegations. The DP is pending. Everything is there. How can he be?
In my respectful submission, that is a subsequent cause of action.
This is only to accommodate, to avoid his promotion. You accommodated him. The malice is apparent on your conduct. The malice is apparent.
Kindly see our report. Kindly see our report.
Each and every paragraph of the report contradicts each other.
The Honorable High Court at Calcutta by the order date.
Where is the compliance report?
There is a compliance report by the statement which has a symbol, emblem of the government at the top.
Oh, yes, I got that. This one.
Yes, this one.
Yes.
Please see paragraphs 5, 6, and 7.
There is no paragraph.
No, there is a paragraph. Kindly see the order. Kindly excuse me.
No, there is nothing. No pagination, nothing of that kind.
No, not this one. But there is a 2 or 3 pages.
2 or 3 pages.
Yes. With an enclosure.
Yes. Yes. I got it.
Put it into that.
Yes, this is the one.
Yes,
This is the
this
one,
this
yes.
one.
The other. Yes.
TC paragraph 5.
Yes.
That as per the gradation list of eligible candidates for promotion to the post of Deputy Inspector General of Correctional Services, West Bengal, the following mentioned Superintendent of Correctional Home, namely not Debashish Chakraborty, Satya Prakash, Shubhendu Krishna, Sudeep Basu and Somik Sarkar, respectively, are in the zone of consideration for promotion, and the said gradation list along with the proposal for promotion to the post of DIG and all necessary enclosures have been sent to the PSC on 16th May 2023. Your Lordship has taken note of the date. Then it is respectfully stated that as is evident from the Annexure A of the promotion proposal sent to the Public Service Commission on West Bengal, there are pending disciplinary proceedings against two superintendents of correctional homes, namely departmental proceeding against Debashish Chakraborty. Penalty of censure for 1 year was imposed on Sri Chakraborty, which has since lapsed. Another departmental proceeding was pending against Sri Debashish Chakraborty, and penalty of withholding of annual increments for a period of 2 years without cumulative effect under Rule 8.2 was imposed on 8th of June 2022. Thereupon, Sri Chakraborty prayed for a review of the penalty order of 14th June 2022 and again with a memo dated 30th of October 2022 under Rule 22 and the Department Video number 15 June 2022 temporarily kept the penalty order in abeyance till review of the case. Consequent upon consideration, the department has reviewed and proposed the penalty of censure in place of the penalty of withholding of annual increments for a period of 2 years and placed the review order before the PSC on 3rd March 2023.
How?
May 2023 and
Yes,
3rd
that's
March.
true. And then?
Then thereupon the Public Service Commission on 13th April 2023 and memo of 3rd May 2023 requested certain additional documents in this regard, and the department video memo numbers and so has submitted the same to the Public Service Commission.
Satya Prakash is pending.
Both
Is a
were
criminal case.
yes
Is pending.
pending. Debashish had 2 departmental proceedings against him and 1 contempt order.
No, no. All ended with the censure.
The contempt order was there. Not, there was one, the other was not. How could on 3rd March 2023 and 13th April 2023 this incident could have taken place when on the previous page they write that by memo the Public Service Commission had sent on 16th May 2023. So everything is subsumed in the PSC's recommendation.
How can you send the name of this the Debashish?
Chakraborty.
Yes, and also Satya Prakash, against whom the criminal case is pending.
We have explained that, but the procedural aspect of sending promotion proposal to the Public Service Commission West Bengal for the post of Deputy Inspector General of Correction Service could not be sent within the time mandated by the High Court due to
No, you have sent, but this is how you have sent. How? I am just asking you that the proposal which was there, you send it on 16/5/2023.
Yes.
This is the first time you have sent the proposal of these 4 candidates.
Yes.
According to you, they are found eligible.
Yes.
And then in the next paragraph, you say that against 2, these are the penalty which is imposed.
Yes.
At least Debashish censured twice.
Against a review petition was filed there on the basis of
No, review. First thing is increment was withheld, then it was reviewed, and then censured.
censure.
Both. He was penalized. And this order was communicated on 3rd of March 2023. How? When your recommendation, when you seek a recommendation from Public Service Commission on 16/5/2023, then how can you wrote a letter on 3rd of March 2023 intimating the review order to the Public Service Commission? Why?
We have forwarded the entire things to the Public Service.
That was on 16/5.
Another thing, not just now my client has provided me in court that CBI court proceedings are pending against Mr. Chakraborty.
When the entire thing has file has been forwarded to the
The
PSC.
definite inclination of mind to
Sir, you
accommodate
are
this
an
gentleman.
employer, and I think you are a noble employer.
No, but we have forwarded all the papers to the PSC. PSC is the recommending authority if they select any.
Sir, you have sent every papers. Have you not said anything about this? That these are the persons against whom all these actions are taken. You have had not disclosed that the CBI inquiry is going on against him.
I have no information.
State does not know about SP. Correct.
What are you talking about? And this is not other administration. It is the police administration, jail administration.
This report was signed.
You do not know.
This report was 17th May, but after that, 19th June 2020, after about more than 2 months, about
Yes.
1.5 months.
Proceedings were
Did
pending
you,
earlier.
you were so keen in forwarding everything to a service commission. Will you not forward this to the service commission?
At that point of time, this order was passed on 19th of June 2023. And the report
Proceedings pending since 2022. The case number indicates.
No, this report
এই যে
was
দাদা এটা দেখুন না পুরো কেস নাম্বার অফ 2022 কেস নাম্বার 13 of 2022.
But report was submitted before your lordships on 17th of May 2020.
That's very unfortunate.
Sir, I am not talking about it. When you are communicating everything to a PSC, why you did not communicate on 3/3/2023 that there is a CBI proceeding which is also pending since to the 2022 against this? You give a clean chit to him so that he may be considered as a favorite or the favorable one. Why?
Now
Communicate. Whenever you impose censure, minor penalty, you could immediately communicate to him. Look, censure, not any major penalty. And this is a serious one. Will you not communicate to a PSC?
That will be when the PSC has considered it. Now, if PSC considered ABC, the 3 persons.
Sir, PSC can take up suo moto for filling up the promotional post?
No.
No. Concerned department hand over or forwarded all the relevant papers and
Those who are
documents
eligible.
to him
Those who are
and
eligible.
with the request to initiate a proceeding for filling up the post. Correct. Is it not your duty to provide all the documents to the
Whatever
PSC?
is available to the department.
This was not available to you.
But
A serious CBI inquiry, the case is going on, and it is not available to you.
No, according
You are an employer.
According to Mr. Mojumdar, just now it has been handed over. 19th of June 2023, this case number 13 of 22.
Mr. Mukherjee, with deepest of respect, we are not dumb.
No.
Don't try to play so intelligently or running.
No. If I have committed, no, but
Go by that date of, we are not concerned.
42.
Go by the date on which the CBI registered and initiated the proceeding. That was of 2022. We are asking you this question.
case number of 13 of 2020.
If this was there, then on 3rd of March 2023, whether you were aware or you were not aware of this case,
On that instruction I believe. No, I shall have to take it. No. Then I shall have to take instructions. What?
My lord.
Disclose this, will take into account.
And when late my landfall.
No, their stand is very clear. I have not. Their stand is very clear. We have received this recommendation on these papers. Where you, these are the 4 persons who are
Eligible.
We have undertaken an exercise and have recommended this. Their stand is very clear. If you have intelligent, I mean, shrewd, suppress identified,
If I have committed any mistake as a counsel, but if no. I'm a learner, my lord. I'm a learner.
Mr. Mukherjee is representing a person. He is referred as you. Sorry. Our attention is drawn to the compliance report submitted by the respondent number 1. on 17/5/2022. Which according to the learned advocate for the petitioner is contains a self-contradictory stand. And the act of nepotism and favoritism can be manifestly seen therefrom. He further submits that there is no disclosure of a case initiated by CBI against the person who have been favored, having suffered several disciplinary proceedings as well as the criminal proceeding. And such suppression is apparent from the, what is that document?
Now, that's an order passed in case number 13 of 2022 by the judge in charge is
Passed by CBI court.
Special CBI court number 1,
CBI court number 1,
Calcutta.
Calcutta. In
ML case number 13 of 2022.
ML.
ML case number.
Mr. Mukherjee, the learned advocate representing the NS contentment number 1 subject. Now, I initially tried to explain the conduct of his bank, taking a plea that since the compliance report was filed much prior to the date of the said order, non-disclosure is the non-disclosure cannot act adverse to his client. But we noticed that the case was registered and commenced in the year 2022. We'll stop. Since Mr. Mukherjee showed his inability to comment further thereupon, in absence of such document being brought on record, we therefore direct the petitioner to file a supplementary affidavit annexing such document or any other document relatable thereto within a week from date. It goes without saying that the copy whereof shall be served upon Mr. Mukherjee immediately upon the affirmation of the said affidavit, the supplementary affidavit. Let this matter be listed after 3 weeks so that Mr. Mukherjee would be able to take a necessary instruction from the said LS contentment number 1. Call the next immediate. What is this?
Happening for the alleged contemptor number 6, Secretary Public
This
Service
is
Commission.
post,
May I file the
post
compliance
service. This is the matter where Lordship heard it in detail, that mechanical, electrical. And Lordship delivered a 35-page judgment. So unfortunate. May I just show the directions of the unfortunate is that they have made a paper gradation list. They made a gradation.
Not the
No.
soft copy.
No. They have made a paper gradation list showing that pursuant to your Lordship's order, I am senior from 2000. Lordship direction was also intested seniority between the private respondent and me should be maintained. He has been made an executive engineer, my boss, despite myself being senior by your Lordship's order from 2000. It is so gross, my lord. In fact,
Affidavit.
Lordship, may I file the compliance report? No direction for executive.
it's similar to, I believe, the similar tone of the earlier matter, similar way.
File your affidavits. Affidavit by 2 weeks, reply 1 week, matter to appear after. Yes.
Lordship will be taking item number 4. Sorry.
16. Where is Miss Kritika Ghosh? What is this? So now dismiss.
Time for the petition.
First time or
My lord, first time.
seven?
Grateful.
3 weeks since. Next.
My lord, I am praying not today, my lord, today.
First time
No, my lord,
for affidavit, the direction for service has been done.
no, my lord. I have to take instruction from my client, my lord. They are not interested.
Not today.
Not today, my lord.
Next.
18, my lord, I am appearing for the petition first time.
Service 3 weeks. Next. 19.
Yes, my lord.
First time
No, yes, it is first.
service 3 weeks. Come. They are entitled to service.
My lord, this matter is second time contempt. My lord, first time
Serve the notice.
other side appear.
My lord, you serve the copy of the content on him.
No.
So you have to serve the contempt now. Serve it 3 weeks.
My lord,
Because this, I will not be available for 2 weeks. That's why we are giving it.
my lord, in the meantime, new incumbent has come contempt now. My lord, kindly grant leave to add his name.
Leave is granted to the petitioner to add the new incumbent who joined the post of.
My lord,
He has joined to the post of.
for ADM, LR, South Chobis Pargana. ADM and LR, South Chobis.
Here and now. Service.
Satham Navas.
On
My lord,
the contemners, including the alleged added contemner.
my lord, contempt. Oh,
Next. देखिए not today. Yes, the first format.
Well, as Mr. Datta is present today in the court, so I call him. Item number 5 plus.
There is the serious allegations made against you. If we correctly, vividly recollect, there was a consensus that it will be. You took 2 days adjournment for that, to take an instruction from your client. We permitted that. Now it is relating to that matter where the garage has to be divided. Everything was accepted by the client. Now they are saying that you have accepted or admitted because without any instruction. This is a serious allegation.
Lordship, may I be permitted to submit?
Because if this is the situation, then we can refer the matter to a bar council as well.
Lordship,
If
may
we
be.
correctly remember, you consciously take the decision, take the instruction and then came. You have to be very fair to the court.
Lordship.
You may represent the client, but the first and foremost duty is that you are an officer of the court and you have to be very fair. What is your stand?
Lordship, on the said date, my client was present in the court. Lordship, I didn't say so, but somehow it has been wrongly recorded in the order.
What?
And if something is caused The inconvenience is caused. I apologize for that, Lordship.
No, it was because the only thing was we had a lot of discussion on the garage.
Lordship.
Only. This was the only argument. And you say that there was no submission. Many a times we asked whether that is viable, that is not viable, what can be done.
Plans were also, my lord, given.
Showing that the garage is included in the first floor, Lordship.
No, not fourth
Ground
floor, garage is the
Ground floor,
ground.
ground floor, ground floor. I
So
stand
far as
corrected,
first
Lordship.
and second floor was concerned, there was no dispute.
Lordship.
But only thing is the relation to ground floor. I think there was some business or something was going on, if I correctly remember.
Lordship.
So we do not want to disturb that. And it was said that it should be given half an hour. Take a stand. I'm absolutely. Otherwise, see to it. Because we have recorded.
Yes, paragraph 5, Lordships have recorded that it is his submissions plus. It was his.
File your affidavit.
Yes,
If you so keen, we invite you to file your affidavit.
So kindly consider my apology, Lordship.
What apology?
I-
Your client was there, everything was there, this was done. Then you file your affidavit that what has happened. We'll consider that. We'll consider.
Lordship, the commissioner's report and the map clearly showing, Lordship, that the garage is included in the ground floor, Lordship.
That is there in the ground floor. Garage cannot be there in the other floor. It has
Area
to be
was
on the
not
ground floor.
Lordship.
It's not a mall or something like that where the garage would be in the upper floor. It's on the ground.
Lordship, I didn't submit so, Lordship, but it
So
has been
file your
it has been
affidavit. We'll
recorded,
consider
Lordship.
that. You'll have to file your affidavit. You file your affidavit.
Plus, one more submission I can have. Just one submission. If the area in ground floor is 871 square feet.
I know everything.
And up first
Sir,
floor.
you have come for the first time.
Yes, Malas, yes, Malas.
So you do not know.
Therefore,
And
therefore,
I
Malas.
will direct my officer
Yes.
also to find out that particular live streaming if it is recorded
Yes, Malas.
on a day. We have a live streaming recorded. We'll go through it.
It was for 3 days or 3 days.
We'll go through it.
Malas, it was not his
We'll go through
property
it.
to
Now
say.
it is very easy.
Not instructed,
Now,
Malas.
now
Law is very
previously it
strict.
was very easy to say that we never argued in the High Court. Now one has to because we have all the records.
Malas,
What is argued and what is
Lordship,
not argued.
may note down one judgment, recent judgment, Malas. It says the instruction given in the court without instruction from the court is not acceptable. Without
He
the
says
instruction.
one thing. He says that my client was present on the day when this matter was finally taken up. But he says that he never submitted in this regard. This is what his stand is. So your client was present on that day. So let him give an affidavit. This is what this comes up from his mouth.
All right, Malas. He may
Your
file-
client cannot say that I was not present. I was there. It's the counsel who has done. Your client was present in the court.
Malas, today also he is present in the.
Yes. Does he not understand what is happening in the court?
Yes. That's
He
true.
understands.
Yes, I was not there.
What
I
is
cannot apprise
happening
your
in the
Lordship
court?
what has happened.
So
But what I
we
found
will
from
we
the
will find out from the recording.
Yes.
Don't worry.
From-
We have the recordings with
Yes,
us. We'll find out.
what exactly has happened in this case, Malas. Therefore, Malas, I'm just
Definitely.
yes, yes.
So easy.
Because
So-
they are the brothers,
so-
Malas.
so-
The peace
so-
should prevail in the family, Malas. Every day they have to fight or else.
Make a blame on a member of a noble profession.
Yes.
Because now those days have gone. It's not so easy that
We have to take care for the other interest of the client.
criminals go scot-free.
No,
No,
we have to take care for the interest of
you
the
have to
client.
be very fair. Sir. So take your fair stand. We'll stick to it. But you have to be very fair.
Melissa, could you please have it some next month somewhere in the,
Let him file an affidavit.
yes,
File your affidavit.
Melissa. Melissa, one thing, Melissa.
Last file counsel against whom? Last file counsel against whom? The allegation is made in the instant review application. Has appeared on the direction passed by this court. And made sufficient in relation to what transpires on the day of hearing of the main matter and the judgment passed thereafter. Considering these submissions, this court feels that he must be given that whatever he has submitted before the court must be taken on record in the form of an affidavit. Mr. What is your good name? Anjan Doctor. Mr. Anjan Doctor, the practicing advocate of this court is directed to file affidavit putting on record the state of affairs or the events happened on the day when the main matter was heard and disposed of by passing the impunity. Within 2 weeks from this.
2 weeks. Could you please have it in the first week of March, Malas? First week of March, Malas, any day.
In the first week of
6 or 7, whatever is convenient.
first week of March. Let us see.
Malas, one indulgence I can have, because there is a directions that commissioner will go and divide the garage.
What?
There is a directions by your lordships, Malas. Status quo, Malas, only status quo. Because if it is done,
Then
Malas, situation would be different.
Kishore Khetan's case of the Supreme Court, 2006, volume 4.
The computer memory of your lordship.
That is second appeal matter, your lordship, in earlier occasion.
Order 41.
Order 41. And another matter, your lordship, for the matrimonial, your lordship, is matter in hearing, your lordship. Ready paper book.
This bench is
This is my application. This is pursuant to your lordship, my lord, what felt that we should come up with a formal application. What had happened was, by an order at page 9 of dated 22nd of November 2023, my lords were pleased to, my lord, dispose of an appeal, my lord, indicating that the trial court should hear out the injunction application and dispose of within a period of 2 months. And, my lord, your lordships were pleased to, my lord, extend the interim order for a period of 2 months. My lord, the hearing has already been concluded, but in sometime in December, before the, my lord, Christmas vacations, my lord, the hearing was concluded. But the problem is the learned judge who had done the hearing, my lord, the learned court below, was on leave because of medical grounds. So, my lord, we had mentioned the matter before and that was the judge in charge. We had mentioned the matter before the judge in charge, taking up the matters of judge in charge. He refused to, my lord, entertain our application and saying that
judge has joined.
But as far as our instructions is concerned, it's still, even as on today, it's vacant. Even as on today, it's vacant.
Current judge in charge is second lady. Who has heard? The judge in charge or the judge himself?
The judge in charge had heard because the original
there.
court, no, may I indicate? The original court was vacant.
Oh, I understand.
Pursuant to your lordship's order, the judge in charge heard. But
He's-
this judge in charge who heard the matter finally is unwell and is not, my lord, coming. And he has now been transferred, I am told. So, my lord, now we had mentioned the matter before the judge in charge taking up this judge in charge's matter, and it fell from the learned court that because I did not do the hearing, it was heard before a separate bench.
No, he has been transferred or
He
he
has
is
been
under
transferred.
transfer.
Now it has been transferred. So, my lord, that is the whole difficulty. If my lord kindly takes a look at the page 9,
Heard afresh.
it possibly has to be heard afresh.
And the parent bench is still vacant.
It's still vacant.
It's still vacant. So there must be somebody who is there in charge.
Who must be in charge, but before whom the hearing did not take.
True, I have found. Yes.
And did not even take my put-up application.
Why?
So I have annexed the put-up application, which we have already served to my learned senior friend's client within the time during the subsistence of the interim order, but the judge did not take.
Where is that?
But if your lordship kindly takes a look at your lordship's order once.
No, I have need not. We have
But the
said.
put-up application is page 17, 17.
We have said that the judge in charge of the said court shall comply the directions passed therein.
Yes, but this was not the judge in charge before whom we moved the put-up.
Whatever. Now the situation is this. So now
Could
tell
have been
me,
taken,
tell
but-
me what. The matter is there. Put-up petition. Where is the put-up petition?
Page 17, this we had sent them by way of WhatsApp, and the type copy is at page 18 onwards. And my extension application is page 19.
And there was an objection noted by the council on their behalf.
Yes. Received copy. The endorsement your lordship will find towards the top left at page 19. And our extension and the order, your lordship's order was still 22nd. We had served this on 19th.
Who is the judge in charge? The civil judge, junior division.
Second additional district judge. Now the judge in charge of, my lord, the civil judge, senior division.
Is a
Second additional district judge at Uluberia, my lord, is the, my lord, judge in charge of the senior civil judge, senior division, Uluberia.
Correct.
But possibly this has to be heard de novo. Possibly, subject to what falls from it.
Obviously.
Yes.
But I don't know what he is referring. No copy of the application has been served on us. On the last
Why?
occasion, when the matter appeared, without an application being filed, your lordship directed them to Lord.
Correct.
We have
so,
not received
so we
anything.
do not propagate
don't know what he is
the
referring, my lord.
procedure
I
of
do not have a
passing an order on oral mentioning.
Then your lordship
So-
directed
so
them.
that-
My junior appeared on that. They knew that we are
Correct.
appearing.
So
They
why
should have served
you
us
did
a
not serve?
I cannot. I don't know what is he referring. It's not with us. Nothing is with us.
Why you have not served?
No, I do not know. Mr. Basu is of the opinion that he has already served. But he does not have the.
Sorry.
আমার কপিটা দিচ্ছি এক্ষুনি দিয়ে দিচ্ছি ছেড়ে দাও।
But I am not appearing for all the parties. I am appearing for only.
You are not supposed to be because you only appeared on the day when
Yes.
this order was passed.
Yes.
So you are supposed to be here.
Yes, not only.
You are for the
I
respondents.
appear for-
Mr. Sumitavo Chakraborty.
But I have
Who is
instructions.
Mr. Sumitavo Chakraborty?
Yeah, Lord, Mr.
So
Chakraborty.
he
is
appeared for the respondents.
Not for all respondents.
I do not know. The order speaks of the respondents.
For the respondents.
We have filed Vokalatnama for 1 or 2 respondents. I am
I
telling you.
do
Lord,
not know, but this was the situation.
Not all.
Sorry.
But I know it's a slip on our part not to serve this earlier, but the only thing which we want, I understand, my lord. Yeah. Well,
No.
we shall come back whenever you lodge.
Tomorrow, take instruction.
Lord, scientists
Tomorrow,
Monday, Lord.
Tomorrow, take instruction.
Perhaps it won't be possible.
Tomorrow, take instruction. Yes. दिए तो no.
Appellate.
Yes.
This is an appeal, madam. It has been assigned to your lordship, criminal. Well, it can't be done within this side of your lordship. So I mean, after the, I'm ready with it, but today, my lord, it's 1 o'clock.
So we can continue. Will it not be finished by?
No, my lord, it's a big
4:30?
matter. No matter, it's a big matter. Because they give a reply. He's for the de facto complaint.
Your role is very limited.
Limited.
State has to. Who is for the state? You are for the state. So
There
you
are
ready
three
with the
appeals.
matter? Yes. Look at it.
For a change.
How many appeals are there?
3. Who are the other appellants? But I wouldn't know. Who's appealing for the others? And I'm appealing in the matter of, my lord, 402.
They are convicted, definitely. They have been convicted.
Imprisoned for life.
Imprisoned for life.
Yes, sir.
302.
Yes.
So, where are others? You are representing one of such.
402. Mujahid Khan.
Yes.
At
least the 2 did not come before 0.
Mala, in the new code, in the new code, 420 is no longer 420.
Yes.
It's not there anymore.
In other 2 matters, lordship.
I mean,
it is out of the same incident. They are.
It's one judgment, same incident.
So, who are representing them?
Well, I wouldn't know, my lord. But I think on the last order, your lordship may find that. One
Mr. Muhammad Abdul Rakib with Mr. Tirthopati Acharya is appearing for CRA 659.
659.
And then CRA 85, one Saryoti Dotto.
Oh, Saryati Dotto.
Saryati Dotto. So he is appearing. So where are they? Are they not interested?
It seems they may be interested. You're not watching the list, maybe.
Do not know. Can your junior go and inform them?
Yes, I'm sending. Boss.
Yes. What is the matter? Can you in nutshell?
Yes, sir.
Any woman is involved?
No. No woman.
Live streaming in this case cannot.
For the writ petitioner responded.
Is what is this? এই আজকে তো কি আছে এটা? Which item? Application. Okay.
For the writ petitioner responded.
What is this? Where is the petitioner?
He was present while Mr. Mike is appearing for the Union of India, the appellant. Because he was present on the previous occasion, my lord. Because he has told him to be present here.
Arun Kumar Maiti, where is he?
No accommodation today. But I am suffering an interim order, my lord.
Interim order passed in the appeal.
Yes, my lord. There was a stay upon the question, set aside of the termination letter. Well, at the same time, the Honorable Division Bench has allowed me to operate the parcel space. But that has not been
Can you
complied.
inform him to come? Can you inform him to come?
Yeah, my lord. I will.
Yes. Asuva, we are making it. Inform him to come.
Yes.
Yes, call the next.
My lord, in this matter, my lord, I beg to appear for the appellant, my lord.
Why you beg, sir?
My lord, because I am a officer of the court, my lord, and your lordships, my lord.
So why you beg?
This is temple of
You are-
justice, my lord.
So don't beg.
My lord.
You have a right to represent.
My lord. My lord, may I file the impugned copy of the certified copy of the order, my lord, because leave was taken to my lord file the appeal, my lord. My lord, there is a delay of 9 days in preferring the appeal, my lord.
You have filed a application seeking leave to appeal.
My lord.
What?
My lord, I filed, my lord, against the order dated 25th of October 2023. Wherein
You were a party in the writ petition?
My lord, I am the writ petitioner, my lord.
Oh, then why you say leave to appeal?
No, my lord, I am filing this appeal, my lord, but there, because my application for modification of the order.
Have you served the copy?
Yes, Mr. Paltu Debra is appearing for the state, my lord. On the last occasion, my lord, he accommodated me. If your lordship so feels, my lord, I can inform him, my lord. Because last time he accommodated me, my lord, I was not present, my lord.
So you inform him?
My lord.
Tell him. Yes, he was appearing on the last occasion. He was not. Tell him.
My lord, just now I'll inform him, my lord. Wait for me.
Yes. Call on.
Well, I have for the petitioner.
Yes.
This is affidavit service.
What are those old applications, 2019 applications?
Well, this is one application for one restoration along with section 5.
Why you did not appear, sir?
Lord, some other part matters are also going on, my lord. And ordinarily, my lord, your lordship kindly, my lord, appreciate, my lord, I am to be in the criminal courts, my lord, CBI and NIA matters, my lord. So what I propose to your lordship, subject to lordship condition, my learned friend is there, my lord. Kindly fix up a date, my lord, after 22nd on any day, subject to your lordship's convenience and convenience of my learned friend, so that this matter can be heard and disposed of.
He says that he is suffering an interim order.
No, my lord, that is there, my lord, and also if your lordship is kind enough, my lord, to consider, my lord, that my lord.
Consider it. Only thing is, are you ready today to argue?
No, my lord, not today, my lord, because after 22nd, my lord.
Then come in the first week of March.
My lord.
Come in the people, I will pray, my lord. As there is a substituting order directing upon them to at least allow me to operate the parcels.
No, my lord, that has been my lord allotted to some other person.
I do not.
I have appointed supplementary affidavit.
But that order is stayed by the division bench.
Yes. And also the concluding part of the order, my lord.
That order is stayed by the division bench.
And at the same time,
No,
same breath.
So that if you are aggrieved, then you can. Why you want a?
My lord, let it be fixed, my lord.
Yes, first week of March.
My lord.
Yes.
My lord.
That is first week of March. Yes, next. Yes, what is your? No other interviews. No other indulgence. We'll see to it. Yes.
My lord, there is a, my lord,
Where is the service?
my lord, I have 100 word.
Today's. Restoration upon condonation of delay. So, restoration upon condonation of delay.
Yes. My lord, my lord.
This is a condonation. 1432. What you were doing? 1432 days delay.
My lord,
In filing an application.
My lord, COVID period intervened, my lord.
What?
My lord, you are dismissed by your lordship, my lord, 18 September, my lord, 2019.
So,
my lord, thereafter, my lord.
COVID, it struck in March, at the end of March 2020.
I missed the, my lord, my lord.
So you came to know in August 2019 itself.
Yes, madam.
You came to know in 2019 itself about dismissal.
No, I came to my lord from when I received information from client that matter has been dismissed. That's why thereafter I filed this application. It was not within my knowledge.
Can 3.
Restoration is coming.
The two applications. Please take down. Can 3. The application is for condonation of delay. The affidavit of service has been filed showing service of notice on 3/2/24. However, there is no appearance on behalf of the respondent. Having gone through the application, the reasons set forth therein, we find that sufficient cause has been made out for condonation of delay in preferring the application for restoration. Can 3 is allowed. The delay is condoned. Can 2. Can 2. The reasons specified in the application for restoration are very much one and the same as specified, as set out in the application for condonation of delay, which we have already allowed. The restoration application is also allowed that the matter be restored to its original file and number.
What is this FMET? Admission stage?
Yes, admission stage. It was dismissed.
41.
On admission stage, it was dismissed.
Let the FMET means number be listed in order 41 rule 11 in the next week.
I'm deeply obliged.
My lord, I'm got the appellant wife. Talks of settlement are going on. Kindly grant us some more time to sort out the matter. Just now they made an offer of paying 40 lakhs. I will communicate with my client and come back. My lord. to
40 or 30?
last day they said 30 just before coming here. They said,
They said 40.
Whether he has added 10 to that.
So your client has enhanced.
I don't know.
just now in the corridor he said. Just now in the corridor he said.
Is the parties are exploring the possibility of amicable settlement of their disputes and prayed for an accommodation in such view of the matter. 2 weeks?
Yes, ma'am.
1 week. Lord, let them, because Lord, I have to pay Lord the monthly maintenance of
Let
40,000.
the matter be listed. Next Thursday, what is the date?
Thursday is a holiday. Next Thursday holiday.
Or Friday?
Friday.
Good.
Friday.
My brother will be holding a bench, that's why I'm saying. Friday.
But if there is not, if they agree to the amount that my client is willing to pay, Lord, the decree will be confirmed here and we'll file Lord a compromise.
Everything will be done on that day. If they agree, then the modalities of payment has to be done. Everything will come.
Grateful.
Grateful one.
I am for the appellant.
Good.
For 209, I am for the appellant. This matter relates to substitution application, my lord.
In
Along
time,
with
out of time.
Condonation of delay, my lord, and your lordship last occasion.
Condonation of delay for? Condonation of delay for?
Yes. Yes, my lord, one thing.
Sorry? You are moving an application, you do not know what is.
Yes, my lord, delay for sir.
Other side is here.
Yes, my lord, Mr. Buddhadev Gosal is appearing, your lordship.
Where is he?
Actually, he was in the court. Now he's out.
Mr. Udayan Dotto.
Yes, my lord.
Where is he?
He was present in the court, but now he's out of court, I think. But last occasion, your lordship, give me liberty to file a supplementary affidavit with regard to my lord setting aside of the abatement.
That is what really we wanted.
Yes, that I have. Lord.
Have you served the copy?
Yes, I have already served. But technical difficulties is shown by regarding the judgment we have shown. My lord, I do not go through the judgment. But situation is if when the matter is pending, in that case, substitution is applicable. But when the matter is not pending, addition is applicable.
No. No. Matter is not pending means what? Then where the substitution or addition will be done?
No, my lord, what happened in my case?
No. First, let us understand the proposition of law which you are saying. What is the proposition of law? What is the proposition of law you are saying? That when the matter is pending, then substitution.
Yes.
And when the matter is not pending, then addition. Where?
My lord.
In air. Where addition is to be done? Addition in a pending matter has to be done.
Yes, my lord.
So,
in my case, what happened, my lord?
That is the proposition is wrong. The proposition of law you are saying is wrong.
No, my lord, actually, what I emphasize to say,
What?
That in my case, your lordship, just 2016, the matter was dismissed by the learned additional district judge. In 2017, I filed a CO against that order, but that was not applicable. But whatever it may be, right or wrong, order was passed in favor of me.
The wrong was detected in the year 2017. Thereafter, first appeal was filed.
And how the CO was in your favor?
So, my lord, that is the question. Order.
So why you file an appeal if the CO is in your favor?
No, my lord, that is the order of the additional district judge. The first appeal is applicable. That is wrongly.
But why you filed a CO?
That is wrongly done.
Then what the court did? Revisional court allowed the CO?
Yes, my lord. The
order was set aside.
Order was set aside thereafter.
Then?
But
But you were happy. But the order is already set aside.
Yes.
So,
but wrong or right, no, that was pending. See, that is what I am saying. That is, order is wrong or right, that was pending.
I am unable to understand.
2016 Millard order was dismissal order was passed.
Dismissal of your suit.
Yes.
Correct.
Yes.
Decree of dismissal.
Yes, your lordship.
You challenge the decree in civil revision.
Yes, lordship.
Before High Court.
Yes. Order.
High Court set aside the decree.
No.
You said CO in my favor. What does it mean?
CO, Millard, the petitioner will serve the copy. This is the order of the CO, Millard. Just I am talking about. But the petitioner will serve the opposite parties to show cause as why the petitioner should not be permitted to apply fresh probate engaged will Badal Chandra Das, notwithstanding order impugned dated December 21st, 2016. So that was the order of the CO, but that was wrong. Whatever, but that was detected later on, my lord. But thereafter, my lord, first appeal was entertained. That is so. In that case, my lord, that is why I am saying that substitution. That is why I am filing substitute application.
I have to unlearn everything. I don't know what he's saying. I am unable to understand as of now.
And last occasion, 2017, 23rd June 2017, it was.
Mr. Mukherjee and Mr. Ghosh, both please ask him what he really want to say. Actually, just inquire from him. What he is proposing, you understand first and then tell me.
Lots.
You understand what he really wanted to say.
আপনি কি এখানে কি অ্যাপিল অ্যাপেল তারপর কি স্যুট হয়েছে কি হয় শুরুতে স্যুট প্রপোজাল ডিসমিস আপনি কি প্রপোনেন্ট ছিলেন আমি হচ্ছে অ্যাপিলের আমি এখানে সাব প্রোবেট করেছিলাম সিও অ্যালাউ করেছিল স্যার তারপরে ভুলটা হয়েছিল ভুল ডিটেক্ট হয়েছিল এক সেকেন্ড অর্ডার লিখে প্রোবেট যে মামলাটা কে ফাইল করেছিল আর আপনি কে ছিলেন প্রোবেট মামলা হচ্ছে আমি পিটিশনার আপনি জানেন প্রোবেট অ্যাপ্লিকেশন করেছিলেন তারপর সে প্রোবেটটা গ্রান্ট হলো না পেন্ডিং প্রোবেটটা ডিসমিস হচ্ছে প্রোবেটটা ডিসমিস হলো তার থেকে কোনো অ্যাপিল পেপার অ্যাপিল হয়নি সে সিও করা হয়েছিল সিও হলো তারপর কি হলো তারপর ফার্স্ট অ্যাপিল ফাইল যে সিওটা ভুল এইটা কি ফার্স্ট অ্যাপিল এটাই ফার্স্ট অ্যাপিল 2019 আর এটা আমি কি অ্যাপ্লিকেশন মুভ করছিলাম আমি অ্যাপ্লিকেশন মুভ করছি সাবস্ক্রিপশন অ্যাপ্লিকেশন মুভ করছি প্রোবেটটা আপনার কি ডিসমিস করে দিয়েছিল কেন দ্যাট ওয়াজ wrongly done. প্রোবেট স্যুটটা টাইটেল স্যুটের মতো ফাইল করা হয়েছিল সেটা নট ফর প্রোবেট ফর as I understand Lord after talking to him
he is just proposing a question of law that since the substitution can only be done if I understood correctly, that's why I say maybe he is not able to express in more clear, because I would have invited had there been another judge in the bench to speak in Bengali so that I will understand. But my brother may not understand. So that is why I invited you to understand. He says that the substitution can only be done in a pending case. Addition is allowed to be, addition is to be done in a non-pending case. So I just thought that where addition will go, in air, somewhere, there must be a pending litigation where the addition has to be done.
Yes.
He says not required. Then he took me that he challenged that particular order dismissing the probate application in CO. In CO, he said initially that goes in my favor. Then I asked that goes in your favor means the order of dismissal goes. So why you are filing the second appeal? That order is wrong, he said. I say, but you are beneficiary. You have been benefited by that order. So he is unable to answer that why, how it goes in his favor and why he is not happy with that order. Then he read some order. I do not know what that order is. But impression which I gathered is that the CO remained pending.
পেন্ডিং আছে না আপনি বলেন ডিসপোজ হয়ে গেছে infructuous
Any order is
so
passed.
infructuous that he means to say
Any order is passed saying that CO has become infructuous. Why infructuous?
According
Not
to the order that
maintainable, I can understand. Why infructuous?
But he says, Lord, as I understand from him, Lord, that
Understand in Bengali first.
He says that the probate application filed by his client was dismissed.
Correct.
He wrongly preferred a civil revision against Lord the
Correct.
dismissal, Lord.
Correct.
Now he has come to Lord his senses to see, Lord, understand that Lord it is an appealable, Lord.
Correct.
He has filed an
good
appeal.
sense. Good sense.
Now this is an
At last, good sense.
appealable order.
Now, it is a substitution application with Section 5. Last time we raised an issue that simpliciter substitution application with Section 5. How? How? Then he says, give me a liberty. I said, please, supplementary affidavit, setting aside abatement, come. Then he says, not necessary. Why you have dragged me, what I understand, dragged me to file a supplementary affidavit for setting aside. No question of setting aside abatement. So that's why we are at fix, both of us. That why, what he really wanted to say, why it is not necessary.
Kindly takes it up on the next day. I'll make him understand, Lord, the ramification, Lord. The Section 5 may not be necessary, Lord, if it is, Lord. I'll see when
then I do not know. Then he said that in this case, the substitution, in this case, no substitution. So we want to learn the law from him because everybody should not remain ignorant throughout his life. It's an everyday learning process. So we wanted to learn.
I am also learning.
So we invited him to tell us. So he was not able to say. That's why we requested you to understand if he can express himself in Bengali clearly so that we can get the idea what he really want to say. Substitution in a pending matter and addition in a non-pending matter.
That. কে মারা গেছে এখানে অনেকে মারা গেছে মানে কোন দিকে মারা গেছে
Now to cut short, unnecessarily we do not want to waste. He filed an appeal impleading the dead person.
That is another issue.
Ask him.
অ্যাপিলটা কবে ফাইল করেছেন আর আদার সাইড কবে কবে মারা গেছে
During pendency of the appeal or prior to appeal? Ask him this.
But let him come back on the next day. He says that I've written down everything in the substitution application.
Yes,
The dates
and he
all
does not
written.
know what is a substitution application. What are you doing, sir? Will you not read your paper and then come back? Have you not disclosed in your application when some of the party has died?
Yes, that is in the substitution application.
Show us.
বার করে প্যারাগ্রাফটা দেখান
And when you filed an appeal,
অ্যাপিলটা কবে ফাইল করেছেন আর কবে ওরা মারা গেছে
you have filed an appeal, I am giving you 14th of February 2019. Tell us. It is on 14th February 2019 appeal is filed. Now who died when? After or before?
The three petitions there. But petition number 3, my lord.
Date.
Date, my lord. Actually,
Respondent number.
Respondent number 3A.
From where 3A came?
But then expired on, my lord.
Before. Before 20th November 2017.
20th November.
So prior to,
Yes.
so
20th November 2017.
এটা তো একজন, তারপর আরো আছে। এটাও 18,
2nd December 2008.
2nd December 2018.
Who?
That is Bivas, that is
Robindranath Das, that is not the, he says, no, Sri Robindranath Das expired on 2nd December and leaving behind his surviving
2nd December?
2018.
18. And who died earlier?
Rabindranath Das. The
Oh,
defendant
Rabindranath, I got it. He's a respondent number 2.
Yes.
Yes.
And who died? Other anybody else?
This is not supplementary in connection with Robindranath.
Then what about any other?
আরেকজন আছে বললেন?
Not. Another Milord.
এটা তো পড়লেন। এটা তো বোধহয়
Debu Bhandari.
20th November 2017.
Who?
There is a Debu Bhandari.
Third defendant. That is maybe
Debu Bhandari.
Yes. Yes.
When he died?
20th November 2017.
Yes.
আরেকটা কোথায় আছে?
Another Milord.
Third one?
Milord.
Defendant number 4, Nanda Das.
Yes.
Nanda Das.
2nd November 2018.
2nd November 20.
What is the relation between Rabindranath and Nanda? Brothers and sisters.
The daughters actually.
রবীন্দ্রনাথের সঙ্গে নন্দার কি সম্পর্ক?
Brother and sister. No, why I say within a span of 1 month, both the brother and sister died. That's why I think.
Yes.
20th November or 2nd November?
So what to do, sir? Substitution? All died prior to the
first appeal.
Yes.
That is, I am saying, Milord, during first appeal and Milord dismissal of the professor, the wrong CO was filed by me. So that is why I am saying. So that I can understand one thing is, and Milord, order was passed in favor of me. Yes.
Again, he sees order was passed in his favor.
But that is that tender my apology. Actually, first appeal was rightly done on 2009.
Now, what to do? Substitution or what?
The file against
That
the
is
dead
why,
person.
Milord, my
against
learned senior friend, you have shown a judgment. The judgment.
Where is your senior friend?
Yes, 2009, and Milord, volume 1, CHN, page 333.
Justice Subra Kumar Mukherjee's judgment against you.
That is not in my.
That is against you.
Yes, Milord.
Yes. So
my lord.
So let us dismiss and treat this appeal as absolutely illegal. I mean, non-est.
No, my lord. Kindly,
and we are dismissing it. The appeal will go.
Kindly give me one chance that I can file a formal application under section 146, read with order 1 rule 10-2. 10-2. Order 1 rule 10-2. 146 section. Can you give me liberty?
What liberty? That is the statutory
Proceedings by or
provision.
against
What liberty is required?
Proceedings. So for my understanding, proceedings by or against the representatives.
Correct.
They were otherwise provided by this court by any law for time being in force,
Yes.
where any proceedings may be taken or application made by or against any person, then the proceedings may be taken on the application may be made by or against any person claiming under it.
Correct. So what does it mean? So it means that the proceeding has to be filed against a dead person and then 146 application to be filed. Is it a spirit of section 146? Is it a spirit of 146?
Order 1, rule 10(2), my lord.
That is a different provision. Don't jump. You have taken us to section 146. What is the spirit of 146? We know of order 1 rule 10(2) what it says, but what about 146? What does it mean? What it says that the appeal has to be filed against a dead person, impleading the dead person, and then make an application so that you can proceed against the heirs or the legal representative. Is it the spirit of section 146?
But situation is this, my lord. What happened? All these things. I do not know when they expired. When they expired, my lord.
So
Because
what is that is what I'm then what course?
I got the information from my learned senior friend, my lord.
Correct.
That is why, my lord, after investigation.
So what is required to be done? What the law says, sir? We have to act in accordance with law. We can't act whimsically.
So, my lord, since it is after dismissal of the suit, and when my appeal is going to be filed, in that situation, my lord, order 1 rule 10 to addition of party.
So what you are saying many things, but what applications you have filed? You are moving your application, sir. Tell me, argue on applications. You are going on a hypothecation, hypothesis. This is what hypothetical example. This is what it ought to have been. It is what, but you have not done anything. It ought to have been, but you have not done. What do you expect from the court to do?
Very well, my lord, I am seeking for accommodation for 2 weeks. Thereafter,
2 weeks. Where is the other side?
Mr. Buddha Ghoshal was appearing, my lord. He was present in the court, but now he is outside the court. I don't know where he has gone as well.
Take appropriate steps. Let this matter be adjourned for a week to enable the advocate and record of the to enable the appellant to take appropriate steps.
Grateful.
My lord, item number 205. My lord, item number 205. My lord, item number 205, the other side is here. Mr. Pantu Devra, London Senior.
Yes. Just wait.
My lord.
Let this category of
Grateful, my lord.
is call the next.
Lordship, I am for the appellant petitioner, Lordship.
But I am appearing on behalf of the respondent.
Matrimonial,
No, Lordship. No.
cost title, sorry, the surname appears to be same.
They are neighbors.
Neighbors or
No, neighbors, Lordship. This is arising out of a suit for damages for malicious prosecution. Suit for damages for malicious prosecution.
have you seen that judgment?
Yes, Lordship. I have deposited the entire court fee, Lordship.
Where is the judgment?
Lordship, I have not brought, Lordship. That is AIR 955, Calcutta 148.
Yes.
Yes.
Yeah, 1985.
Calcutta 148. तो धीरेन्द्र नाथ की कैसा रहता है?
Spirit of law, what is nature of law?
এই তো আমরা
So,
Lordship, we have deposited.
yes.
Lordship, the defendants are the appellants before your Lordship. The respondents filed a suit for damages for malicious prosecution, and it was decreed ex parte. Challenging that, Lordship, we have preferred this appeal. There are two applications, Lordship. Can 2 is for condonation of delay. There is a delay of 208 days, Lordship. And
What is the
Can 1 is
explanation?
for stay.
What is the explanation?
Lordship, our case is that we did not receive summons, and for the first time when we received notice of execution, we came to know, and thereafter, Lordship, we applied for certified copy, and thereafter, due to my client fell ill, and thereafter, Lordship, we have filed, and we have also preferred an Order 9 Rule 13 application before the trial court. That is pending.
Perhaps, no, your lordship will come to the judgment. He has annexed page 9 of our
Yes.
application for condonation of delay. Page 8, the judgment starts. I am on page 9, second paragraph. It transpires from the case record that the defendant received summons but did not appear in the suit, and accordingly the suit is running ex parte. And my lord, in her stay application, in the specific case, on oath, they have stated that the appellant petitioner have never received any summon, and hence the petitioner never got any opportunity to appear in the suit and did not file any written statement.
Have you ever come across with the cases where though the court has proceeded to pass ex parte decree, ultimately in Order 9 Rule 13, the court held that there was no service of summons?
But on record, from the record, your
So
lordship,
it is a matter of record. The court will consider under Order 9 Rule 13.
yes, my lord.
We are not at the stage of Order 9 Rule 13. We are considering a case where appeal is filed assailing the judgment, ex parte judgment and decree.
I appreciate it.
Now we have to see whether you have been able to prove it or not prove it. Summons served or not served is not a question in this appeal. I am simply asking you question, only asking you to say anything on condonation. She has said that she did not have a knowledge. She has said that there was a medical emergency. She was admitted there.
But if your
Medical
lordship so pleases,
documents
my lord,
are there.
I can file an
What
affidavit.
you have to say about filing of this appeal belatedly. That's all. Whether merit will consider. Only this appeal is filed beyond that. Tell me on that.
Then, my lord,
What is- explanation. There has been that there is no difficulty. Both the presidents, there are judgments to that appeal. But if the appeal is a it is on yes.
Well, so far as the stay application is concerned, but I will remind
will consider.
Which is the application for condemnation?
Lordship, can two.
Can 2 has been filed. Seeking condonation of delay in filing the appeal wherein specific case has been made out of lack of knowledge and illness of the appellant in the intervening period. The reasons set out in the application are found by this court to be sufficient cause for condonation of delay. We hereby condone the delay. The application is allowed.
Stay applications
Lordship.
listed
That
in the
is-
next week.
Lordship.
Stay application is, oh, first line देखो. That's the appellant has put in the deficit court fee as pointed out by the staff reporter. VDA
Document number 2 dated 8th of February 24.
the office is directed to include the set the court fee with the memorandum of appeal immediately, and then this order.
Lordship.
But so far as the stay application, Lord,
Next week listed.
Lord, defendant in the money suit is the appellant before your lordship.
Stay application.
Stay application as well as there is an application for condonation of DL.
How much days delay?
269 days.
Who is appearing for the
I
other
got
side?
the opposite party plaintiff. Your Lordship directed me to file a affidavit in opposition. Your Lordship has directed me, Your Lordship, on the last
Yes.
occasion.
But I've explained the delay that even before the passing of the judgment, my father, who is aged about 79 years, is admitted in Udrant Hospital. I have also annexed the relevant documents, and that is the reason I don't even I unable to adduce evidence in the trial court also. Explained in paragraph 4 to 9, my lord.
Normally we do not, but probably she might have said some very, very sterling fact. That's why we wanted her to file an opposition. I think you told us on the last occasion that the steps in other proceedings were taken.
Yes, Your Lordship.
During that.
There is a
interval.
criminal revision pending
If
before
I
the High Court.
correctly remember,
Yes, Your Lordship, correct.
And
in another criminal proceedings.
Yes, Your Lordship. I have annexed those the relevant documents with my affidavit in opposition. Your Lordship, the decree has passed on 22nd of July 2022. In their Section 5 application, they have given one prescription of May 2023. May 2023, stating that his father was ill from last 1 year. And for that, they have given only the medical test reports of May 2023. I have given the papers that in the month of August 2022, that is immediately after passing of the decree,
they have filed one criminal revisional application against me and the state of West Bengal in the Honorable High Court, Calcutta. And the learned advocate who contested the case in the lower learned court below, he appeared in that criminal revisional application in the Honorable High Court, Calcutta. Beside that case, the defendant appellant has also appeared in another criminal case in the learned CGM Howrah. So it's not the fact that his father-in-law has prevented them from filing this appeal, and no sufficient cause has been explained by them. They have given only one prescription of May 2023, only the documents of May 2023, and nothing else. And in their reply, they have only deal my these papers with evasive denial.
Yes, what do you say?
I have also given Malat the medical certificate of my father.
What it says that, yes, she is not disputing that your father was not hospitalized or suffering a lot of diseases, but says that that does not really constrain you from taking steps in the judicial matter. In fact, you have taken steps in the judicial matters during the pendency of the illness of your father. If you have taken those recourses, then why in this you should get an advantage?
No, Malat, I tell you, Lordship, Malat, I have also specifically stated that since Malat, I am unable to take the steps, I don't even Malat appear before the trial court for giving evidence. And that is the reason, Malat, the fact of the case, Malat, that though I have executed the deed of sale, I am suffering Malat money decree.
I do not know.
Since I am unable to place the money, Malat, the original deed before the court below. That is the case, Malat.
I do not know. Then why you did not contest it, sir? You can go and file a criminal revision. You can go file
Malat, this is a quashing application and Lordship knows very well.
That requires coming to the court, making an affirmation in the court. Everything is required to be done.
And the same advocate appeared.
So, and the same advocate who is prosecuting this case was engaged in that suit. Why he did not take any steps? There is no allegation against him. So what to do? There must be some plausible ground that we can understand. But if the documents belied your stand, then what more the court can do? The court is not supposed to just pass an order without looking at those.
In High Court, Malat, the matter was filed on Malat 30th.
After the decree was passed. This is what she is saying. So if you can come and file a suit proceeding, then you could file an appeal also.
But I have stated that I was not aware with the trial court proceeding during this period. I was not aware with the trial court proceeding.
But the same lawyer, is there any affidavit by the lawyer that I was not aware any date to be fixed in the suit? Wrong posting in his diary, anything of that kind? You have not taken out those, you have made out a case like that. Obviously, this is not a case at all.
The advocate, as I find, my lord, from their opposition, the criminal revision filed, the learned advocate was Varsha Roy. And in my trial court, and in my lord, in trial court, the advocates were different. Mr. Pratik Mojumdar, my lord, the advocate.
How much is 39?
Krutik, but Krutik Mujumdar was a senior, he may be briefed by this Borsha Rai, but my advocate was Borsha Rai. And also, lordship, in High Court, the client used to come at the time of affirmation.
So if he had come, he could have gone there to depose.
But I don't have that.
Or at least the application could have been made for adjournment.
It is
something could have been done. Nothing. You have taken only a plea of the illness of your father. Nothing more than that.
No, this is the. I must say, this is
and the same lawyer who was representing here, you representing here, was representing in a suit.
And in other
The
criminal
interest-
proceedings in the learned CGM Havana, they are also appearing.
This is the case when letter came from the advocate. No, this is not a case. Okay. Yes.
But kindly consider my
Huh? Yeah. I will put signature with a closure. That's true. That's true.
But kindly consider, though I have executed the, this is a case where I am suffering money decree, though I have executed the deed. And more so, on merit,
2013 suit, your lordship.
and
in the year
more so, the
2022.
document which is the basis of the money decree that has not been produced, not even exhibited. This is the basis of money decree.
They have cross-examined the PW, everything was done.
The agreement for sale, which is the basis of a money decree, that has not been even produced. The Xerox copy has not been produced. Only on the basis of avowment, the decree has been passed. Not been exhibited also.
By giving a prescription of May 2023, they have explained the delay of 1 year, your lordship. And in between those
But
1
I have
year,
the medical
they are pursuing
certificate of
the other
the
legal
doctor also, my lord. I have the certificate from the doctor also.
prescription of 1 certificate of May 2023, your lordship. And in between suit for a money suit that I have entered into an agreement with the defendant for purchasing a land, but they have not executed the sale deed, and so that the suit was filed for return of the money of 5,46,000. The agreement for sale was for 19 lakh. My advance money was 5,46,000. The learned court observed that I have the receipt of 446. That's why the learned court granted the judgment and decree of 446 lakh only.
The most interesting part, my lord, most interesting.
Payback later.
But it's not a matter of payment of 4 lakhs. The only issue is
The
I
plaintiff
can
is a very
show
poor
only
man.
2
He's a
pages.
lift man.
Only 2 pages.
He's a very
Number
poor
one, my
man, your
lord,
lordship.
number one, the schedule of the plaint. My lord, kindly appreciate, my lord.
Will you pay back?
My lord, kindly appreciate, my lord.
Will you? Then we will appreciate everything.
My lord, I'm ready to deposit in them before the.
Will you pay?
Without prejudice, my lord.
Whatever.
Without prejudice, I will pay, my lord. Because
it has been executed in your favor.
No, deed was not.
Yes, my lord, that is my
Execution.
Execution is pending.
Pending. Oh, auction sale has not been done.
No, execution proceeding is pending.
My lord, I will pay. But my lord, lordship, for my satisfaction, kindly peruse 2 pages. If your lordship, then my lord,
My brother will peruse it, and whatever the decision he will take, let him take.
my lord, for my only 2 pages. My lord, I will not take not anything.
Convince him.
My lord, I will pay. I tell you, lordship, I will pay, my lord, for this 4 lakh. But lordship, kindly peruse these 2 pages. The schedule of the plaint and the deed, what I have executed. Lordship, the deed.
Deed was executed.
I have executed.
Deed was executed for another land, your lordship.
Only
That
the
they have,
Khatri
they are only saying
lordship,
that
kindly.
deed. And learned court has rightly observed that deed also in the judgment and decree.
My lord, kindly peruse
That
the
deed was also observed in the judgment
schedule of
and
the
decree.
plaint and the deed I have executed. Kindly see 2 pages. Then, my lord, I am ready to pay, my lord. But my lord, kindly peruse these 2 pages.
He's a very poor
Because,
man, your
my
lordship.
lord, there is nothing remains for execution.
They
I
cross-examined
have already
the plaintiff.
transferred the
They
property.
cross-examined the plaintiff in detail. And thereafter,
He's a very poor man, but
he's a lift man. He's a lift man, your lordship. He has
the land.
4 lakh.
Such a price.
He has hard
And my lord,
money,
the
your
agreement
lordship.
for sale has not been
That's why
produced.
he's contesting this.
So he has a hard-earned money.
Yes, your
So
lordship.
he's not a poor man.
Yes.
He's a more reputed, respected person in the
He's a lift.
society. That out of his hard
Yes,
work.
that's
he
why
has
he
got
is still
so much
fighting, your
money.
lordship. He has some.
Why you say poor man?
They are only
The
dragging the
most
case.
respected man of the society.
Malad, moreover, the agreement for sale that has not been produced, not been exhibited. And Malad, the money quickly passed. And I have executed only 2 pages can satisfy that I have executed the deed. The plot number same, area same, Khatiyan same, everything same. Everything same, Malad. Only kindly Malad page 49 once, kindly peruse page 49. Malad, kindly consider, Malad. Malad, only Malad, page 49 and page 90, Malad. Thereafter, Malad, I'm ready to pay him, but only 2 pages, Malad, for my satisfaction. Stay application, page 49, the schedule of the plaint.
Lordship, I am not served with this stay application. I have served with only section 5 application.
Malad, page 49 schedule, kindly consider. All that piece and parcel, no, Malad, it is a kindly, Malad.
What are you saying?
No, Malad.
Money suit.
Page 45, page 45, Malad, page 45.
Not a suit for specific performance of an agreement.
Malad, this is a money suit.
That's true. Simplicity of money suit. Why the schedule will
No,
come?
Malad, paragraph 1, page 45. Paragraph 1, page 45. The schedule of the land, what I Malad proposed to sell. One kata, 12 cheetah, 30 square foot land with one storage pakka house consisting of 3 rooms, bath, privy included.
For a total consideration of 19 lakhs.
Total 19 lakhs. RS Dag numbers.
Whatever is there.
Now, Malad, kindly consider page, the deed, what I have executed. And that is the Malad, my counterclaim based on that. The deeds were executed on 14 lakhs. And my counterclaim that I am entitled for remaining 5 lakhs. Now, Malad, kindly come. Page 85 of stay application. This is the schedule of the deed. And the English part, Malad, find on the map, that page 90. Schedule. Kindly see, Malad. Same plot, same Khatiyan, same area, everything is same.
Khatiyan is not same. Khatiyan is not
same.
It was, what was the consideration price?
Here, Malad, the deed was consideration price is 15 lakhs. And it is my specific case that I have been forced to sign the deed. And that 5 lakhs is remaining, and that is, Malad, the counterclaim of 5 lakhs is there.
What happened to a counterclaim?
Malad, since Malad suit decreed, Malad, my counterclaim dismissed. That is the reason, Malad, I prefer 2 appeals. And Malad, the basis, that plaint stands on the basis of agreement for sale. Lordship, kindly see, Malad, the exhibited document. The agreement for sale has not been exhibited. Not even the Xerox copy was produced. There is no reference in the entire judgment that the court looked into the agreement for sale. The very foundation is missing of a money suit.
Your Lordship, can I show the judgment and decree part now?
Which property you agreed to purchase is paragraph 1.
I have
what
not
is the sale deed which was executed in your favor? Both the schedules are same.
No, both the schedules are not
But
same. I
that
have
what
not
is the
served with the
difference?
case.
I'm giving, Malad.
Sure. That it is in respect of different property, then you can't term your client as a poor man.
Yeah, just a minute. In my application, I have stated that I have entered into agreement for.
This is paragraph 1. Paragraph 1 is the plaint. Is your plaint, sir, madam. It's your plate. So you can't improve anything else. Description is given by you. And look at the deed which he executed. Same description.
No, they are Khatiyan numbers are different, Your Lordship.
Khatiyan number is not. What is
Just
the
a minute.
difference between a Khatiyan number and a Dag number?
I'm sure there are two there are two plots in the same dag.
So there
There are two plots in the same dag of the plenty or the
no.
Your Lordship, there are two plots of the defendant in the same dag. They have sold me one plot.
Meaning of the word Dag. Tell me.
They have two plots in the same dag.
Can it be believable under the land system prevalent in the West Bengal?
They have two plots.
Now I'm coming because you are grown up in Calcutta. You have no idea about the rural areas. Your house is numbered as one fierce lane. Can there be a two plot in one fierce lane?
No. No.
Dag number connotes a plot. And if there are two plots, then there will be a two dag number. If it is, and I think that segregation or the bifurcation from a main dag, then also the dag number remains, we call it a bata.
Bata dag.
So there cannot be one dag number for two plots. Khatiyan number is only for the purpose of making a person liable to pay the land rent. And there will be a one khatiyan for one person. A person who is holding the land in a different districts, several plots of land, then there may be a one khatiyan. Am I correct, Mr.? Yes. So, one khatiyan, one person, one khatiyan. So that all his properties are included in that khatiyan. If there is two khatiyan, that means there are two distinct and different persons for each. So you can't say that the dag number is same for two plots. Improbable, unbelievable.
Dag number are same. Khatiyan number have.
Khatiyan cannot be.
Khatiyan of that defendant has no two khatiyans.
It's got no relation with
He
the
has
title.
purchased the
Khatiyan
property.
number has no relation with the
The
title.
defendant has purchased the property from someone. The khatiyan of that person is reflecting in the deed.
Because, my lord, I tell your lordship, I have also explained.
Mutated and getting.
Yes.
That's why, and that khatiyan is reflecting.
That is what is the very. But the plot number and the tag number is
The same.
Area also
And
same.
they have sold with another land. They have sold with another land and they have taken the entire consideration money.
The descriptions show us from your deed and from your paragraph 1 that the description is different. I am asking you to do that.
Give me some time.
87, 85, 90 the planters.
Your Lordship, I need some time to study all these papers in that case.
What is study?
Your Lordship, I don't.
I am studying here and now. Where is the paragraph 1?
Paragraph 1 is at
page 45.
Page 45.
Yes, it is, I am saying.
85.
It is a 1 kattha, 12 chitaks, 30 square feet of a land with 8 feet side circle in RS dag number. What is this? 1793 or now LR dag number is 1734.
LR dag number 1734
And
must be.
within Moja and then J. Anyhow, this is what is there. Now tell me, show me the
Moja Bakshara, PS Jogaja district.
Show us the
page
schedule of
85.
the deed.
85.
Where is the date?
Topshil Sampati is the GL number 7. Havla Municipal Corporation. What is it? RS 793.
Yes.
793 is there.
Yes.
793. And
just Mallet from page 90, Mallet find the English version.
Your Lordship can.
For his Lordship, page 90 is the English Mallet.
Anyhow, we will go to the hall number.
One kata.
1738.
Yes.
34. 1734.
My lord.
LR is
LR.
1734.
Yes.
Ek katha, 12, 1 katha, 12 chitaks and 30 square feet.
Yes. Same.
Your Lordship, can you see the Khatia numbers? Lordship, can you see the Khatia numbers? The Learned Trial Court has deal all these documents. Can you see the Khatia numbers one? In the plain, can you see the Khatia number, Your Lordship? In the plain, the Khatia number is mentioned LR Khatia number 4492. And in the deed, it is mentioned as 4488 and 4489.
Have I not said something to you?
Lordship, those two plots are different.
Please go read the West Bengal State Acquisition Act.
Lordship.
Earlier is the Bengal Tenancy Act, and then the West Bengal Land Reforms Act. How the plots are being categorized, how they are, what is the role of a Khatiyar number, what is the role of a JL number, what is the meaning of the word Mauja, what is the meaning of the word Tag number. Please go read that and then say Khatiyar does not, again I am saying, you are misconceived.
Lordship, I need some time to study all these documents because today I was prepared for the Section 5 application. I have not served.
I have defined this deed that has not been executed in your.
No, I have given this deed as an exhibit in my money suit. I have given this deed. I have given this deed, Lordship. Today was the date for Section 5 application. That's why I prepared for that. Lordship, I am praying for only 7 days time to prepare all this. Only 7 days time. And kindly direct them to submit those.
With the execution then.
No, I am not proceeding with. The date is in the month of March or April.
Because they are not proceeding with the execution because nothing remains. They have already.
There is many things remains.
Yes.
Your properties, your bank accounts are
Yes,
all
that's-
remain.
Lordship, kindly tell them to give a copy of the application Section 5.
But in course of the day, I will.
Give up.
Yes.
Lordship, I will come back, Your Lordship, with all my study.
Study as a junior, but
Lordship, the Learned Trial Court has deal that they have given me the different.
don't go. Then what is the purpose of the appellate court? If everything has been done by the trial court, then there is no utility of the appellate court to be constituted. Then that is sacrosanct. Why the appellate court will be there?
I will
If
show
they
you.
commit an error, that's why the appellate court is
Much
there to
obliged.
correct it.
Yes,
So
Your
don't
Lordship. Much
go by that the trial court has considered. Again, I am saying, there's a misconception in your mind, correct it. You are asking for a time, we are giving you a time for a week, but correct it. Yes. You have not appeared before Justice Bhajpal Bhattacharya and Justice Subramanian and Justice Anil Kumar Singh.
I have appeared before this Justice Subramanian Mukherjee.
Justice Anil Kumar Singh.
No, before
Next time.
The senior will tell you what would be the fate. He will tell you before Justice Anil Kumar Singh.
But kindly fix. But kindly don't fix the matter on next Thursday, my lord. Any day, my lord, other than next Thursday.
Yes, simply said not this way.
I'm praying for 7 days time, Your Lordship.
So ask before when it is taken out.
My application for condonation of delay, Lord,
Service.
for preparing the appeal.
Service.
Yes. Sab. But I have explained, Lord, page 5, paragraph 13, 14. 103 days delay.
Now,
Let us explain lot page paragraph 13, 14. And not general honors. But practically not COVID time.
I do not know. Nowadays, everybody is taking a chance of referring an appeal against an ex parte decree.
That is.
They do not know the risk.
Here is the not on merits.
They do not know the risk.
Yes, that's. But merits not.
You can't, because whatever is stated and whatever is deposed, you can't, because your defense is not there.
Here is the not merit simple not.
Simple, we will not. What has been stated in the application and what the evidence has been given.
Yes.
That's all. We will not look at any other thing. Appeal against an ex parte decree. It's a ground.
But on merits not I am telling not explanation. Yes. But initially not your lordship can see but first matter settlement is going on lot COVID time. I am the impression lot that it was settled. But subsequently I could not contact with the matter.
Matrimonial. So,
Initial not Hindu Marriage Act they filed. Then amendment Special Marriage Act. Degree passed Hindu Marriage Act.
Item 215, my lord, I had been directed to serve this application, my lord. I've served, but my affidavit of service is not ready yet. No, no, you're not appealing for my junior, my lord.
Oh, I thought that she.
No, no, my lord, it's a mistake. No, my lord, the affidavit of service is not ready, my lord. Kindly gives me another week's time. I'll prepare the affidavit.
Prepare the affidavit, not
Okay,
today.
but not today, my lord. Just say.
Lord 16, I am for the petitioner. Lord, this is just. Lord,
This one.
the suit for partition declaration and permanent injunction.
Partition.
Declaration and permanent injunction. But the interim order has been refused. But against that, this appeal has been deferred. But before that, a leave has been granted on the earlier occasion by this court that at the time of filing of the appeal, the defective
Interim was refused.
no interim injunction at interim refused. Therefore,
Thereafter, the injunction application itself is rejected.
rejected. And
Let us why we invest time on an application. Let us dispose of the appeal.
yes.
Only 2.10.
Yes, just then let him argue.
Only 2.10. All co-sharers not included in this suit. And entire properties not included in this. Entire scheduled property. That is the finding of the landed court.
No, this is not a correct. The one Keshav Chandra Das who is the original owner. The landed court below given findings that the co-sharer of the Keshav Chandra Das has not been a party. On that ground, the misjoiner and non-joiner of the parties and interim order has been rejected. The question of non-joiner and misjoiner is a party is the matter of fact. That will be decided at the time of trial. Not only that, the co-sharer Keshav Chandra, the paper record of rights has been finally published in the name of the Keshav Chandra Das, who has been expired in the year 1986. Since 1986, no partition has been made. The son of the Keshav Chandra Das has been enjoying the property of the Keshav Chandra Das. And petitioner plaintiff is the legal heirs of the married daughter of the Keshav Chandra Das. So they are deprived from the enjoying the property of the Keshav Chandra Das, and at this stage they taken plea যে co-sharer of the Keshav Chandra Das as yet not been party on that ground the injunction.
Who is the co-sharer of the case of Chandra?
Well, the plaintiff and defendants.
No, they are the heirs and successors.
Successors of the Keshav Chandra Das.
Co-sharer means there must be somebody else
who are the brother and sister of the Keshav Chandra Das. But I do not know.
Neighbors.
Yes.
Alien.
But I do not know who is the.
They disclose.
My
disclosed.
No. They never disclose.
The persons who are the co-sharer. You are a grandchild of the
Keshav Chandra Das.
And the defendants are.
The defendants are of the sons and grandchild and grand of the Keshav Chandra Das.
Any other heirs of the Keshav Chandra?
No.
They have not.
All are the parties.
Properties purchased by Keshav Chandra Das and Kanai Lal Das. There are
so many things. Have you disclosed this in the trial court in your opposition?
No.
I have
in your written objection, have you disclosed that it was purchased by Keshav Chandra Das and Kanai Lal Das?
Defendants.
Page 42, written statement.
I'm just
Yes.
asking if in the written objection also in 38. Please, Mr. Ghosh, you practice in the civil side, you know. Tell us from your opposition filed before the trial court, you have said that
paragraph 39.
Please show us. We wanted that.
So the other co-sharers of the suit plot are necessary parties to.
I am again. Who are the other co-sharers?
The name mentioned, name not.
So something is just heard without naming it, and the court will believe your story. You have not disclosed anything.
Name not mentioned.
Then how he will make them a party? You would have immediately taken out an application for addition if you say so that he can proceed.
Deed of title,
Sorry, you have not produced anything.
there are several deeds.
Disclose them.
Standing in the name of
And any evidence deholds the pleading is not admissible in
God full orders.
law. You know, there are series of judgments of the Supreme Court. There is a complete copy.
Well, certified copy.
Sure. No, the case is different because there was a LR record of right that was produced.
Yes.
There, the court said that from the LR record of rights, it appears that apart from Keshav Chandra, there are other co-sharers whose names are recorded. Those have not been made a party.
No, Maharaj, kindly come to the page 51.
Who was that?
Yes, page 51. This is a record of rights of Keshav Chandra Das.
Yes.
That I filed the suit only in respect of the property belongs to the Keshav Chandra Das.
If it is a larger property which comprised in a one dag.
No, there is several dag. Several dag. One dag.
Then could be. And the share has been given.
No. Kindly come to the page 51.
Which dag number is the subject matter?
All dag number is the several dag number. The page 51, 687 by.
See, subject matter all. Now it says Dager note Poriman hoche 1.31, then 0.75, all these things. Then Dager note, then Onsho. Then the Onsho has been divided. So that means it does not have the entire share. Out of 1.31, the first one, he has the Onsho, and then in apropos Onsho, how many acres he has.
But
there are others. That is what the court has held. You proceeded as if.
Keshav Chandra Das, in the name of the Keshav Chandra Das, is the final publication, the record of rights. He is owner in respect of the dag number 3687, the 36 Soto.
This is the dag number. And this is the nature of the Jabi. It's a Khani, Dharin is the Pari. Again, it says target mode Poriman means the total area of the dag is 1.31 acres is acre. And the target mode Octopus forte onshore means the name this much of share this so it is less point something.
And this is the
The
leftover.
total acre is 0.36. So out of 1.31 is having 0.36 acres of land. So what less is a share. It's for the half of 1/4, 1/5. So this much of share.
This is the area.
To this much of area out of this. So it is more than 1 acre.
Well, in the record of dice, this is the system to incorporate share and measurement. But I am paying only for.
You attended the class of C.R. Das, retired IS officer from the land department.
No. But my contention is.
If you want, what he says that all these things, he very meticulously says that each thing denotes what.
But my contention.
What does it mean when you take the first instance, 687? It says it's the Dhani land.
Dhani land.
The total area is 1.31.
31.
Out of this, the Keshav Chandra Das holds 0.2734
Yes.
onshore.
Yes.
That means the share.
Share.
And then apropos that onshore, he is entitled to 0.36 acres.
Yes.
That shows
36
out of 1.31, the Keshav Chandra Das has 0.36 acres of land. Means
he is possession of that land.
rest the land belongs to somebody else.
Yes. I am not on that.
Now, if the entire land measuring 1.31 is not demarcated,
But even if that also demarcated.
Can a partition suit lie in respect of 1/4?
Yes, yes, because oral partition is itself is the partition. Yes, because my lord, my on my own.
I have to unlearn, sir. Because the concept of joint property is that in every inch of the properties, co-sharers have a joint right, title, and interest. Visualize the situations that there are 4 persons having 1/4 share in respect of this row, and one person, Mr. Ghosh, applies for a partition, or his son applies for a partition, sons, and say 1/4 divide amongst ourselves because my father has 1/4.
Yes.
1/4 will go.
Preliminary degree, partition suit is the 2 degree, 1 for preliminary degree. My share would be declared by the my share would be declared.
Final degree?
Final degree, well, that is the subsequent fact. But my right.
Subsequent fact means?
Because which
how you will pass a final degree? Tell me. Let me learn.
Marat,
how the final degree?
own satisfaction.
Without my brother, without you, how can a final degree be passed?
Marat, my contest.
Say that this is one of the best property side, rear side. Who will take care of that?
Marat, oral partition also a partition. No. If the co-sharer of the
oral partition between whom?
Between the co-sharer of the Keshav Chandra Das, and Keshav Chandra Das is now.
Provided Keshav Chandra Das owns the entire property exclusively, no doubt. Who says?
It is not possible because, my lord, I am a married daughter of Keshav Chandra Das. My lord, my marriage was harmonized before 18th, and I go to the matrimonial house. Now law has given liberty to enjoy the property. In what manner I will know that regarding my paternal property will be divided or not undivided, even if.
So law of evidence has to be read.
Certainly, no, my lord.
Even if you claim your right, you are not supposed to know how your right came.
But that means I have no right of the property of the Keshav Chandra Das. If I have a right of the Keshav Chandra, the property of the Keshav Chandra Das, I have a right to the file a suit for partition. Otherwise, 1986, my grandfather has been died. Since 1986, the sons of the.
Who says that you cannot file?
If my right, my prima facie right, there is my property, then I am entitled to the injunction in the form of status quo in respect of the partition suit.
I will keep my exhaust your right.
My lord, maybe am I wrong? But my
Let us then decide. Correct. Let us go. The application for injunction filed by the plaintiff appellant is rejected by the trial court, primarily on the ground that the co-sharers of the plots for which the partition suit is filed have not been impleaded in the said suit. The plaintiff appellant claimed themselves to be the heirs of the Keshav Chandra Das through his daughter, and filed the suit for partition, declaration of shares. Filed the suit for declaration of share and partition and separation thereof against the other heirs and legal representatives of Keshav Chandra Das. The defendant respondent, after appearing on a notice having received under Order 39, Rule 3 of the court, took a defense that the suit is bad for non-joinder of necessary parties, as the co-sharers of Keshav Chandra Das has not been impleaded in the suit. Though there has been no disclosure of the names of the co-sharers of the said Keshav Chandra Das in the objection, written objection, as well as the written statement filed by the contested defendants respondent. Yet the court, on the basis of the documents produced by the plaintiff appellant, found that the co-sharers of the Keshav Chandra Das have not been impleaded as a party, and therefore it would not be proper at this stage to pass a temporary injunction as before. The counsel for the appellant is very much vocal in his submission that the suit for partition is restricted to a land belonged to Keshav Chandra Das, and heirs and successors of the Keshav Chandra Das having impleaded in the suit, the trial court committed serious error in holding that the co-sharers have not been impleaded as party. At the first plus, we found support in the contention of the plaintiff appellant, but after perusing the documents annexed to the application for stay, in order to ascertain the correctness of the findings recorded in the impugned order, we find that the LR record of right is also annexed to the said application, which in fact had been relied upon by the learned judge in the trial. The law in relation to a partition of an immovable property is somewhat settled that if all the co-sharers have not been impleaded party in the suit, the suit for partition is liable to fail. it is also no longer recentegra. No, it is no longer, it is also no longer recentegra that the suit for partition, that a suit for partial partition cannot be maintained unless all the joint properties are brought within the hodgepodge. Stop. Taking clue from the aforementioned proposition of law, let us consider whether the finding of the trial court that the case of Chandra Das did not hail the property exclusively, but was a co-sharer along with the others, are correct. The counsel for the appellant took us to counsel for the appellant relied upon the LR record of right annexed at page 51 of the stay application and submits that all the plots mentioned therein are the subject matter of the suit for partition instituted by his clients. We have meticulously seen, we have seen from the pair reading of the entries made in the same LR record of right that the case of Chandas was holding a share in the plot of land as mentioned therein, and not in its entirety. Take, for example, the first entry made in the LR record of right where the tag number 687 is shown to be a paddy land having a total area of 1.31 acres, out of which the case of Chandas is shown to have a share to the extent of 0.2734. Which is equivalent to 0.36 acres. Since the case of Chandas has not been shown to own the entire plot of land comprised of 1.31, he is regarded as a co-sharer in respect of the said plot, and therefore it is imperative on the part of the plaintiff to include the other co-sharers who are holding a right, title, and interest in respect of the remaining land. A point is sought to be urged before us by the counsel for the appellant that since the partition suit is restricted to the share of the case of Chandra Das, and it is not possible that all the co-share, it's not possible to gather or collect any information regarding the other co-share. There is no fetter on the part of the court to pass a preliminary decree declaring the shares of the parties to the suit. We are unable to comprehend the aforesaid proposition of law for the simple reason that in a partition suit, not only the court is not only required to pass a preliminary decree, but must also pass the final decree segregating and dividing the property, the larger property, in commensurate with the shares declared in the preliminary decree by meets and bounds. We are unable to appreciate the stand of the council for the appellate that the courts adopted by the court after passing of the preliminary decree for the purpose of the final decree is a subsequent event for which the court should not wait or detain itself to stop. The purpose of the partition suit would be frustrated if it ended at the stage of a preliminary decree, as the party who finds a said suit intended to separate his share from the rest of the co-sharers or to the exclusion of such co-sharer and to enjoy exclusively stop. For such reasons, the concept of bringing all co-sharers on record is inevitable and all the joint properties within the folds of the schedule of the said parent is also inflexible. We thus do not find that there is any error and or infirmity in the impugned order passed by the trial court. However, we make it clear that certain objections, certain observations made in the impugned order have a persuasive impact in the maintainability of the suit, which should not have been done at the interlocutory stage, and therefore we hold that those observations are mere tentative in nature. We have said the suit is not maintainable.
Yes, but only
You can apply for an implement, whatever you want to do it.
But
we said that
only direction may be given to the dependent to supply the name of the co-chair of the Keshav Chandra Das. Otherwise,
very simple. There is a BLLRO.
Yes.
That's enough for you.
No, there is. No, হবে না BLR if I if I do not know the name of the I am not unable to withdraw the record of rights.
Yes, let's call the next.
The defendant is the appellant before your lordship. The suit for partition, section 5 application, there is on the last occasion, on last occasion, your lordship, I remember that I referred one judgment, Justice Dipankar Datto. Now, my lord, the bench, the single bench of this honorable court.
After the Supreme Court, what more?
Your lordship, kindly go to once for my satisfaction, paragraph 7 and 8. Yes, it is 2017, volume 4 ICC, page 427. 17.4 ICC 427. My lord, paragraph 7 and 8, your lordship, kindly. Before proceeding to deal with the points urged before this court by the petitioner, it is necessary to remind that the court should not adopt a hyper-technical approach in considering an application under Section 5 of Limitation Act. An application under Order 9, Rule 13, the expression sufficient cause appearing in the said aforesaid provisions lexically means that the cause appears to be probable and sufficient to render justice between the parties. The court should encourage the determination of the disputes on merit rather to nip the same at the nascent stage. The meritorious matters should not be defeated on the Hon'ble of the sufficient cause having shows Hon'ble of the sufficient cause having shown or not shown. The length of delay is immaterial, but the sufficiency of the cause is that the court may refuse to exercise the discretion in absence of any sufficient cause. I leave it to your lordship. On 4 decision, I have on earlier occasion, I have shown your lordship on
A single judge judgment before the division bench.
on earlier occasion, I have shown the 2 decision judgment, but this is principle, the principle same. I leave it to your lordship. If you lordship it,
binding on the division bench, why you are citing a single bench decision?
not binding, that is true, but the principle is the same. The principle is the same.
Let us see what the Supreme Court has said.
Let us see, Supreme Court has said, on earlier question, I have division bench.
On the same two.
That is, Dipankar Datta has this cited, same self. Your lordship. ওটা দিয়ে দিয়েছি তো যশোর কতবার দেবো আমার এর বাইরে আর কিছু বলার নেই কিছু হ্যাঁ হ্যাঁ 2023 volume 10 SCC page 531. I leave it to lordship. If you lordship refer, I have no.
You have nothing to say. Yes.
Yes, nothing to say.
First time.
Because my lord, they are day laborer. My clients are day laborer and they ignoring law and only one piece, my lord. Appeal filing, section 5 and section stay, all are.
Lump sum.
Lump sum fee. Deliverer, eat mathay boy nahi jai.
They are cultivators, lordship. It is their case that they are cultivators.
ঠিক আছে, চাষি কোথায় পাবো?
Now, lordships will kindly come to section 5 application, lordship. What is the sufficient cause shown by her? Lordship, paragraph 5, page 7 of the section 5 application. Your petitioner states that after, lordship, it was a suit for partition. It was contested by them, and lordship, thereafter, preliminary decree was passed. Your petitioner states that after passing of the said judgment and decree, and upon obtaining the certified copies thereof, the parties to the suit property have proceeded for amicable settlement, and for that reason, both the parties have assured that they will not proceed with any further approach to the preliminary decree that has been passed by this learned trial court.
The order sheet was there.
No, lordship, we could not get, because lordship, this is for Malda, it will take some time. I could not.
We wanted that order.
I know, but lordship, we have applied for it, but lordship, we could not.
And secondly, I tell you,
Yes.
subject to what my brother will take a decision. In a partition suit, when the preliminary decree is essayed, my view is this, that if a right to appeal is taken away, then what happens? It is not that it will affect in presenti them, but it is a posterity who will suffer that. And this borrowed, this expression is borrowed from Rajia Begum's case of the Supreme Court. 1956 or 50.
Then, Lordship, I should be compensated
Supreme Court.
adequately, Lordship.
The Supreme Court has also said that if this is done, then not only he or she, that was a Razia Begum, it was a Nizam of Hyderabad, their properties, related matters were there. That's why he says that if you do not, that was a case of addition. If you do not add her and hear her, then what will happen? She will be deprived because they were saying that she is not a legally wedded wife of the Nizams of Hyderabad. Then what will happen is she is deprived, but her offsprings, all the posterity they will. Here also the similar analogy, if you take preliminary degree, there the moment the share is declared that she is having 1/4. Rather, if we, in the appeal she can say that not 1/4, it should be at least one third. So if the appeal goes, then posterity they will be deprived.
True, Lordship.
Just
But
imagine.
Lordship,
That is what I know. Very weak. You have everything.
but then,
in
Lordship,
your
I should
armory,
be adequately
everything in your
compensated,
armory
Lordship.
compensate.
Adequately compensated because, Lordship, the delay is more than 1,000 days, Lordship.
Yes.
And Lordship, they have practically, they knew about this decree, they participated it, their Lordship in the proceeding, but your Lordship will kindly. Lordship, suit was decreed in 2018, Lordship. Now, Lordship, to drag the proceedings, now suddenly in 2023, he has filed the appeal.
She was prevented from that. Now the thing is that she participated there. If you think we can fix the matter for hearing also, we can decide it.
Yes, yes.
You can decide it on merit. If we find substance, fair enough. Not substance, dismiss. Need that certified copy of the order sheets.
That can take some time, Lordship.
Yeah.
So that is somewhat relevant.
The Lordships want to allow this application.
What I'm thinking, I'm just inviting
Yes,
your
then
attention.
Lordship, those copies will not be required, Lordship. Because Lordship,
Can we bring the lower court record?
Sorry, application to allow your Lordship call for records. You allow this
Lordship Commissioner has
application.
already, Lordship, submitted the report also.
And I've also stay application, your Lordship directed it to serve. Well, I have already
Yes.
served. Then your Lordship call for records and other thing, your Lordship.
Subject to, she compensates, Lordship. 1,000 days delay. Because, Lordship, her clients are day laborers. Lordship, they carry bricks. My client is also, Lordship, day laborers. Same.
তো তোমাকেও কি করে কি করেছো
So, Lordship,
তাহলে
they
তোমাকে
will also suffer. Regarding that, Lordship, I have, Lordship, judgments to cite.
it which is
Regarding that, Lordship, cost part, your Lordship will decide.
How much?
চল বাইরে চল
বাইরে চল
কষ্ট কি দিল
Lordship, with that, your Lordship decides, considering Lordship 1,000 days delay. Because, Lordship, this is a partition suit. Now, if Lordship today.
So how much per day?
10 টাকা করে বাবা 2000 না 2000 total. No, not I'm saying. No, not I'm saying. It is up to your Lordship, after considering my client's position.
Lordship will also consider my client's position also. Because now, Lordship, of first appeal will be.
That's why see, you tell us.
At least 20,000 rupees.
20,000? My goodness, baba, একদম না। বিক্রি করে দিয়েছে তাহলে পাগল হয়ে যাবে।
Then it will show her bona fide lordship. If she is really interested to contest, she will deposit the money lordship. It will show the bona fide of her client. If she is really interested to contest the proceeding, she will deposit.
That's a very fair and very convincing submission.
Then it will prove that he doesn't want to stall my proceeding.
Condition of stay.
That's the fair and very
Will stay at the time of considering the stay application.
Why stay? This is from partition suit.
Really, you are interested in pursuing your claim.
Yes, yes, I'm interested.
Be evident if you deposit an amount. Otherwise,
Yes.
you may drag on the.
No, not that. No. That is not my intention.
Show your bona fide. She has
You
suggested
see,
that amount.
your lordship did decide it. Your lordship
Suggested the amount.
No,
20 rupees a day.
no, my lord. My lord is supposed to much. My lord, may I?
Under the Minimum Wages Act is near about 680. Skilled or non-skilled?
So they are cultivators, lordship, not
skilled or non-skilled?
Unskilled.
Unskilled.
Then it is 450. From there, 20 rupees.
My lord, your lordship, kindly, my lord.
450.
Kindly, my lord, at least.
I believe so.
At least, my lord, 5,000, your lordship. My beseeching, your lordship. Cost.
at least
5,000.
5,000, but up to lordship 20,000.
No, up to total 5,000. Cost rupees 5,000. I'm beseeching your lordship. Otherwise, my clients. Pardon, my lord. They could not bear all this, my lord, 20,000, 10,000. They are poor laborer, day laborer.
So your client will share amongst, there are two persons, so they will share.
Two are brothers.
Two persons.
Two are brothers.
Both are working as a day laborer.
Both.
They are earning independently. What are you talking about? That's an independent income.
My lord.
So.
My lord, 5,000. I'm beseeching your lordship. 2,000. 2,500 each. Then 5,000 total.
Make her agree.
এই কনসেপ্ট করে দিই কেন বলছে ওরা খুবই গরিব সত্যি তারপরে আমার ফাইল হারিয়ে গেছে আমার কি মনে করা তোর নেই আমার
I leave it to your lordship. I leave it to your lordship.
ঠিক আছে বসে বসে
টেলিকাস্ট হলো কি সবাই দেখলো কি
উপরে চলছে এই 6-7 চলছে if you are
Ms. Sarkar, what
my
is
lord,
your actual claim in the why you are agreed by a preliminary defense?
yes, because my lord,
let us think that there is any point.
Anything
you say. Your share is declared as.
My lord, I'm
Lordship 60.5 decimal.
My lord, suit
What is her share?
My share is declared 1 minute, my lord. My share is declared, plaintiff share declared 102.5 decimal and our share 260.5 decimal. Now, my lord, what happened, my lord?
Just a minute. Contest against the defendants. Number 1 and 3, ex parte against the such and such. The plaintiff has a right title and interest. Yes.
And
declaring the plaintiff as a co-sharer to the extent of 102.5 decimal.
Yes.
And all the defendants, you are a defendant.
Yes.
Defendant number
1 and 2.
1 and 2. They have 260.5.
Yes. And now, my lord, last portion, your lordship, and directed to deliver eviction suits, just like in eviction suit, to vacate the suit premises and deliver vacant possession. Yes, that's why. Before a final degree. That is enter.
Across a preliminary degree of this nature.
Yes, that's why I'm.
It can be done at the time of final degree.
Never.
That has to be set aside.
Eviction suit, that means.
Set aside here and now.
But lordship, what is her?
Will keep
yes.
problem?
No.
No, what is her claim, lordship? She claims.
No, please consider. She is not disputing that this share which is declared in the preliminary degree, that the plaintiffs have 102.5 decimal and all the dependents have 260.5 decimals. She has no remark.
No, lordship, that is not her case. Lordship will kindly.
She has no remark.
No. Mana share I have challenged, my lord. Share I have challenged.
On the
certainly.
Registered deed.
That's true. I can understand.
Just
this is
last
now.
Eviction
I thought that this is absolutely wrong.
yes, eviction suit. Vacate the possession.
It has to be set aside.
Set aside.
Lordship.
ওটা হয় নাকি partly part হয়?
Partly, lordship. How can this appeal be now allowed? Then, lordship, everything has to be heard, lordship.
That means we have to set aside. Now, what is the share? How you say 260 or a plaintiff has a lesser? Because on what basis?
I shall prepare. Do another date, your lordship, and do that. Your lordship, kindly fix a appeal hearing date. Another. I shall contact my client. Your lordship, now. Yes.
Lordship will kindly come to page 10 of the judgment, lordship. That is her case.
আমাকে একটু উপরে যেতে দিয়ে আমাকে
No, just I wanted a broad idea. What?
Yes, lordship. They are saying that, lordship, we executed one Ongikar Patro, and through that, lordship, apparently we have sold our share to them.
To them.
Yes.
Now this Ongikar Patro is a registered document.
No, nothing.
And is there any consideration price which is shown there?
Yes, it is shown. Lordship will kindly see in page 10 itself, lordship. He stated that the transaction was made of a sum of rupees 50,000. He said that it was 60,000, but on evidence he said that not 60,000 but 50,000. So there is dispute regarding that consideration money also, lordship.
And she has not applied for a specific performance or filed a counterclaim till now.
No.
And this Ongikar Patro is of 1992.
Yes, lordship.
So today also
But
what remains?
My lord.
If it is not a registered document, can
No, your lordship,
Ongikar Patro
appeal hearing, your lordship.
More than 100.
No, I'm
unnecessarily when we are talking about, I tell you, Shaka, now very seriously. If we find that there is some merit in your appeal, we will definitely condone the delay and then decide the appeal on merit. If we find that there is nothing on merit, the only thing is that this portion is absolutely wrong. At the preliminary degree stage, court cannot pass an order. It is only at the final degree stage when the properties have been allocated to different and somebody is occupying the another's portion, then he is supposed to make it. I can understand. So this has to go. But if you cannot show,
yes,
if your share has to be altered only on the basis of his Ongikar Patro, then you have no case.
Yes, my lord.
Unless you show that it is a registered document.
Yes, well,
And 1992, it is not that 1805 or 1806.
My lord, your lordship fix, your lordship fix a date, I shall instruction.
Yeah.
I shall take instruction.
My brother is here on Monday.
My lord?
On Monday.
Yes.
Monday?
Yes.
No, not Monday, my lord.
Tuesday.
No, Tuesday, my lord.
Friday.
Friday.
Friday week.
No, my lord. I shall, my lord, talk, my lord. I shall talk my client, my lord, is staying at Malda. Okay, well, I shall instruction, well, I shall take instruction.
What instruction? You have already taken everything.
No, no, no. You know, at the time of appealing, at the,
Take the date.
my lord,
Take the date. Which date?
my lord, eight now, my lord. 8, 9, no. But 2 weeks, after 2 weeks, my lord, 21st March, my lord, your lordship, I beseech you, my lord.
February.
21st February then. 21st February.
21st February?
বাবা মাথাটা খারাপ হয়ে গেছে
On that day, along with section 5, everything.
না না সেকশন 5 টা করে দিচ্ছে
We will do it. Don't worry. At one go, we will do it.
বাবা
And we are fixing this matter on 21st. In the meantime, can you get the copy of that order sheet or
Perhaps.
you know how to get it?
Oh,
well in the meantime well stay
Let the advocate and record there take an inspection of the records and then take a note. On his letterhead, he can
an application for stay application your lordship
21st, they will not be moving it. Don't worry. So, after hearing the respective counsels, let this matter be listed on 21st February to be taken up as the first matter. It's however made clear that in the event this court allows an application for condonation, the counsels have agreed that they will argue the matter on merit.
section 5 my lord section 5 allow this
no.
যে পাল্লায় পড়েছি আমি বাবা
Yes.
This
is all the next part.
I for the respondent.
My lord, Mr. Shaptangshu Basu is appearing in this matter for his personal encumbrances. He instructed me to ask the
encumbrances.
He has some
That has come.
personal difficulties, my lord. He will not be able to appear today. After 16th, any day, he said he will appear. After 16th.
After 16th.
After 16th February, my lord, any day.
19th?
Not sure.
I have got administrative meeting also. I have got a administrative.